Hello. How are people doing? Hopefully, everyone is doing well. Um, I suppose I should comment on this because people have been discussing things in the chat here. Ian was looking for a stab likely dark alley last night. Really, I was, um, and I was disappointed that the alleys were too brightly lit. So, yeah, the basically I've got a little thing that was sent to me for testing. It's supposed to help sort of do things in the dark. Not those kind of things. Bad chat. but yeah, I need darkness to test it. And yeah. This is a good question here. Rob Longo, any tips for someone starting law school in September? Yes, and this is going to be the same tip you're going to get from all of your professors, and it's because it's a good one. I got a few tips actually. Tip number one is um, do your reading. Keep up on your reading because I can tell you that everything else gets easier. If your professor gets up to, starts explaining something and you've done the reading and you understand what they're talking about because you've got that context, you're going to learn more. And you never want to be in the situation that lots of your peers are going to be in, where you get to the end of the semester and you have so much to learn because you didn't learn it during the course of the class and now you're screwed. So keep up on the reading. The other thing I'm going to tell you is that nobody in your classrooms will remember the person who always has their hand up, and always is like, hey, I've got an intelligent question or whatever. Um, Nobody will remember that, or if they do, they won't remember you favorably. What people will remember is they will remember the people who were kind to them and who were decent to them. So be decent to your fellow students and they will remember. Um, yeah, don't be a gunner, be a decent person. That's really the key things there. Having a master's degree in economics helped me get hired in corporate law. Can't hurt. But a lot of what they're going to be looking at first and foremost is going to be your law school marks. So keep those up. If you want to get into like big law and doing those big things, then that's important. So, hey, Uncivil, I see you need darkness. You could borrow my heart. I don't think that'll work. I need something that doesn't absorb the infrared light. All right. So, what is it? Yeah, definitely do the reading. I had a classmate who was about to be called on, but he didn't do the reading and just got up and left. The Socratic method is that's what they call that, where they just sort of call on people at random and say, hey, you, what's the answer to this question? Now, that's falling out of favor in a lot of law schools because it can be kind of embarrassing or humiliating, especially for the people who haven't done the work. But some profs still love it. But even if you're not going to have faced that from your profs, you still want to make sure that you have done the reading. So, all right. Just posting on Twitter because I realized I forgot to say, hey, I'm live now. All right. Just posted that. There we go. So I've got a drink here. I've got I couldn't make a dark and stormy. I was saying that I was going to make a dark and stormy, but I couldn't. I am out of dark rum. So instead, I've got a London Mule equivalent. And I see Robin Shermantine with the member chat. We are angelic, Ian, never naughty. I think we both know better. And Angie Torres, thank you very much for the gifted memberships. It's much appreciated. All right. So today what we're looking at is some appellate court. And normally when you see, LawTube streaming things, normally what we're streaming is stuff like trials. Now, trials are an important part of court work and an important part of the justice system, but they're not the only kind of work that gets done in a courtroom. And in fact, some of the big important stuff is appeals work. If you ever think, hey, do I want to like go down in history for winning a big case? It's not really the trial lawyers who typically are accomplishing those big changes in the law. It's the appeals lawyers. And so appeals is an entirely different game than trials. And so I got started watching this because of the firearm stuff that's going to be in there. But I also am. I also wanted to cover some of the stuff that happens before it because I think it's interesting and I think it's a good way to sort of look at appeal stuff. And thank you as well to Pants for the 10 gifted memberships. Much appreciated. All right, let's pull this up. Did I see Corey's video from earlier today? I did retweet it. Check out Corey's stream. I believe he's trying to help get his mom up to 100,000, which just shows you how much he really cares about other people there. So, hi, student life. All right. And if the text box in the bottom is blurry, that's probably your settings. What I would suggest is go to your settings. It'll be in the bottom right, and it's probably set to like 480 or something like that. So you're probably not getting great resolution. All right, let's just see if I can get this video file to properly open because that's always fun. There's a joy there. Now I'm sort of playing catch up here because what is it? We are Rob and I were originally, we sort of had a notion that we were going to be doing the Trials of the Century sort of pre-show planning thing today as a members only. But Rob is still dealing with some stuff. So this is kind of a fill in there. Bonus Runkle, priceless. Thank you, Vez. So, all right. I missed out on ChatGPT transcript. It was epic. I will have to watch that on replay. Guys, go check out Uncivil's channel and see the replay on that one. All right. And people are asking, where's the tie? I got to unpack the tie. That'll happen later today, but I got to unpack the tie. All right. So let's see here. So right now we don't have any audio because this is just set up. So I'm going to try to skip ahead. I think it's about 5 minutes that they're going to start calling the case. Can I mention the success of appellants versus respondents in appeals? Usually the respondent wins in an appeal because the respondent was the one who won at trial, and appeals courts don't like to disturb findings unless there's a good reason. So usually the standard review, usually that ends up putting it so that somebody else, usually it's hard to win on appeal. Appeals are for losers is sort of the old line. All right, let's skip ahead a little bit more, see if we can get to where they're actually...
Trim.
We'll get to where we're actually starting here. All right. So they're rising.
United States Court of Appeals for the Ninth Circuit is now in session. Please be seated.
Now, can everyone hear this? Is the audio good? That's going to be the first question on this one because you never know with these things. And one thing you'll note here is that there are no witnesses. There is no calling of evidence. There is no anything like that. All you get is the three justices, or however many at different levels of court. There'll be different numbers of people on your panel. But yes, they've got a 3-justice panel here, so that's what you're doing. You're arguing your case to these 3 justices. Now, you will have already submitted written argument before you get in the room. And I can tell you that usually this part that we're watching isn't where appeals are won and lost. Usually appeals are won or lost on those written arguments, and you've already won or lost before you step in the room. They will have read all of those and decided who wins. But I will say that I think more people lose appeals in these oral arguments than win them. But sometimes it can be changed. So yeah, if you poach it hard, yep, I have. Yeah, and sometimes it's where they've lost. Yeah, the justices are going to be asking questions. Now, sometimes you run into what I call a cold fish panel, where the justices just don't say anything, but usually they're going to ask you questions. I see if they're won on the written arguments, what's the point of the oral arguments? I say usually they're won or lost on the written arguments. Sometimes the oral arguments change things. And most especially, they're going to be asking you the questions that they think are weaknesses in your case. They're going to be asking you, they're going to be trying to pick apart your argument. And if you can't stand up to that, you can lose your case in this, in this setting. So you got to come prepared. All right.
Good morning and welcome to the Ninth Circuit. Before we begin, a small housekeeping matter of the cases that we've already submitted. They are De La Cruz Seda versus Garland, Dinza versus Garland, Quiros versus Garland, Burkhart versus Campbell, and Trim versus Reward Zone. The first case we'll hear today is Perez versus the United States.
Now, one thing to take note of is that each of the people on the panel is going to have their own personality, and you'll start to see that fairly quickly. If you practice appeals work in a particular area, then you'll probably already have some idea of what your panel is like in terms of who they are. And hey, Nicholas Starro, welcome to the chat.
Good morning, Your Honors. Jessica Agutstein, Federal Defenders, on behalf of Ms. Veronica Perez. This case is about whether a U.S. citizen can be convicted because the EPA and Customs say they failed to declare pesticides that are legally available in Mexico. It's also about whether the government can order a U.S. citizen to pay $13,000 to throw out about a bag full of pesticides that could have been returned to the store in Mexico for free. A lot of issues in this case. I want to make sure we hit the jury note and restitution, as well as your questions. So I'll start with the jury note. So the court answered a jury note wrong in this case. It took out an element. The first element of Section 545 has two components, has a smuggling component and a failure to invoice, failure to declare component.
So I'll just sort of stop here. I like her intro. Like, I like the beginning of it where she's, she goes in. I actually thought she started out fairly strong. I don't like the introduction aspect of like her introducing herself. The justices already know who she's there to represent. I usually breeze through that as quickly as I can. Good morning, justices. Runkle, first initial I, here, here for so-and-so. Or as defense, you don't usually even have to say here for so-and-so. So you can just be, good morning, justices. Runkle, first initial I, and then launch right in. And the reason why I want to get to arguments right away is that everything is on the clock. Like, we're used to watching things like the Depp trial, which went on for weeks, and other trials, which are these big, lengthy productions. Your appeal, you get, it's like, hey, you've got half an hour. That's it. That's all the time you get. And I see Uncivil saying at the U.S. Supreme Court, you don't introduce yourself. It's a big no-no. That's good to know. I don't expect I'll ever be at the U.S. Supreme Court, but yeah, I mean, often they just already know who you are. You also get typically a very limited amount of time at the beginning. And what I mean by that is that you launch in and eventually they're going to interrupt you. They're going to start hitting you with questions. So anything you want to say, you get a very short time of free speech, of free talking to the, to the court. And if you waste that, you don't get it back. So I want to launch right in and just start hitting them with my arguments, the ones I think are strongest, the things I want to take them to, because you get about 2-3 minutes before they say, oh, let me interrupt you with a question. And then you're on their terms. So we're going to see that here. She gets a little further than I thought she would, but
component. And the court took one component completely off the table to the jury. And for that reason, this court should reverse.
Now, the court also gave an instruction, right? And the instruction was instruction 11. And that instruction was modeled right after our model instructions, correct?
That's correct.
And so the jury had in front of them the right instructions, yes?
Yes, as well as the wrong
Because
instructions.
you already,
so you see, she basically got in about 2 minutes. So when Huncivil says 2 whole minutes, wow, that was basically 2 minutes that she got to talk. I did like her beginning where she says, this is a case about, this person being arrested for bringing this in and whether they can be made to pay $13,000. That was good. But then she gets into the weeds. I also liked how she says, I want to cover this one issue and this other issue as well. Telling the court, let's cover these things. I know you're going to take me into a whole bunch of questions, and we're just, I want to make sure we hit these points. Please ask me some questions about that. I hate it when you start on a prepared argument and the judge interrupts and takes it all sideways. There's a reason it's laid how it is. This is appeals work. You've got to be ready to have them take you off of the of where you want to go. So yeah. Is there no record, as in a clerk taking minutes? Wouldn't that need an introduction? Usually you've already sort of provided your name to the clerk before the justices come in, at least a lot of the times when I'm doing these things. The other thing is that your name is almost certainly on your appellate brief, like what you've submitted. So they already know who you are before you walk in the door. Now you see he's asking this guy, the bald guy with the gleam on his head there, he's starting in and she's making an argument to say, listen, they gave the jury bad instructions. And he says, didn't they actually have a copy of the correct instructions in front of them? And I actually think she does pretty well on that question when she says, yes, but they also had the bad instructions. So that was a good reframe, right? So that was good there. Now you can see he comes in and he is, I put him in the sort of grump category. He's sort of the, and I know this is going to sound terrible in terms of my descriptions, but sort of the grumpy guy who goes and says, well, isn't this some BS and blah, blah, blah. And the thing is, when I started practice, when I did my first appeal, I hated the grumpy justice who is going to be like, well, isn't that some BS? Now I love that justice. That is my favorite justice on a panel. And the reason why is I want them to ask me the hard questions because I want to be able to patch those issues up. I want to be able to convince them that the things that they think in their head are the weakest parts of my argument are not weak parts of my argument. So I used to hate these guys because they will sometimes give you grief. Sometimes they'll be rude to you. But these are kind of my favorite justices. I see somebody saying this sounds stressful. It is. Appellate work is basically a mad 30 minutes often.
You've already agreed with those instructions that
Correct.
they were okay. And when the answer to that question came, it was smuggling goods or merchandise is a general description for the crime set out. Now, that's true.
Yes,
That's right in the general description, right?
yes. So
Okay, so then the next phrase is, smuggling merchandise in violation of the statute is comprised of three elements as set out in instruction 11, right?
right.
This is where you don't want to be as a lawyer. She's in a bad place. Keep in mind that these justices were lawyers once themselves, and now he's cross-examining her. He's feeding her questions, and you see how she's just like stuck answering yes, yes. That's because he's conducting a cross-examination. He's taking her to where she doesn't want to be in this argument. And so the best way to deal with this, if you're in this position, is this is often where you want to be like, yes, but, and take them off of that line of questioning and into where you want them to be. Because if you let them cross-examine you into an admission that hurts your case, like where you give up an argument, and I've seen this. I have seen lawyers say, well, I'll yield that point. And it's like, why would you yield that point? You might actually have won on that point if you didn't just give up and, because you were getting browbeaten. So this is like, to borrow a line from Archer and, classic music, she's in the danger zone.
That's true, including the failure to declare the merchandise for invoicing, knowing the invoice was of a type that should have been declared, and acting willfully with the intent to defraud. That was the answer.
Correct. So the jury here asked,
What was the wrong part of that answer?
And you see how she starts trying, like the jury here asked, and he's like, no, I have control. This is a bad place for her to be. He's going to give her some grief here.
the jury asked, is there a distinction between failure to declare and smuggling? And the court responded, smuggling is a general description for the crime.
Right.
That's
which it
legally
is.
correct in the abstract, but in response to the jury's question was confusing. It took smuggling off the table. They asked for, are they two distinct things? And the court said, well, smuggling's just a general description. So this court said in Peterson.
What they said was,
Now, I actually thought she did better here. Here, when there, you see that the justice tries to cut her off, and she keeps going. She's like, no, let me make this point. And it's a good point she's trying to make. She's saying, listen, the statute says smuggling. They were trying to say is failure. Like what she's trying to argue, and I'll give you a little bit of background here. The background here is that this person bought a bunch of pesticides in Mexico. Now, Mexico has different safety standards for pesticides. And some of those pesticides that you can buy legally in Mexico are super freaking toxic. So she was trying to bring some of these super freaking toxic pesticides with her to the States. And she gets up to the front. They say, hey, do you have anything to declare? She says, nah. And they look in her purse, and in her purse, she's got super poison. And so they're like, how about that? That's something to declare. Do you have anything else to declare? And she says, yeah, there's a bunch of other stuff in my car. So this is why they're trying to draw this distinction about like smuggling versus, just a failure to declare, because she's trying to spin this as this is just that she forgot to tell them, or she didn't tell them that she had this stuff. Whereas she's trying to distinguish this from like if she'd hidden it away in a secret compartment, like some sort of James Bond or, international drug cartel kind of business. She's saying, no, that's not what it is. She's just not being fully honest with them. So we'll see how the court deals with that.
that the statute in regard to it was a general description, and then it referred it to jury instruction 11 to say, in order to get smuggling merchandise, you've got to go for all three elements in 11. And if you look at all three elements in 11, Smuggling is right there in number 1.
In Castillo
This is
Mendez
also true.
and Peterson, this court made very clear it's no answer to say that the supplemental instruction was to be read in light of the original instruction. When the court answers a jury note correctly in the abstract, but confusingly in response to a question, this court reverses. And here, the jury was really confused. Is smuggling the same thing as failing to declare?
Are you suggesting that smuggling is not just willfully failing to declare something that should have been declared?
Yes.
This is going to be a huge point. What is smuggling? What does it mean? And he's saying, wait a minute, are you saying that smuggling and willfully failing to declare are different things? Now, I actually think her argument here is not going to fly. I don't think she's going to win this one. Because ultimately, I think the court is going to determine that smuggling just means trying to bring something through without telling them and without, and knowing that you shouldn't have done that. I actually think that's how they're going to go. But, we don't know. And so here she's forcefully responding. Yes, those are different things. Vez from Quebec is saying, is the party's time stopped when the justice is asking questions, or is it just gone? I think it's just gone. I'm not actually certain, but I think it's just gone. So in most appellate courts that I know of, it's just your time up there. And so one of the worst things is if you can get a justice who really likes to hear themselves talk. An uncivil is confirming, just gone. So if you've got a justice who asks you a long, winding 5-minute question, that's 5 minutes you don't have. And so at that point, they're gone. Justices may eat it all. The justice can sit there and basically just run out your clock for you. So all of this, when he's going into a long time, this is why interrupting a justice can also be an important skill.
That's our argument. And that's because the statute includes both smuggling and failing to invoice. If Congress wanted this smuggling to be defined as failing to invoice, it probably would have said failing to invoice. It didn't. It said smuggling and failing to invoice in the statute. That's what this court's model jury instructions say. They include both smuggling and failing to declare. And that's the instructions we agreed to in this case.
Okay, let me ask you.
So the argument she's making is they say you have to be both smuggling it and failing to declare it. So smuggling has to mean something over and above failing to declare. Not a bad argument.
The next question, did the court's answer change the theory of the case at all?
Yes.
Well, when I read what the underlying people argued, and I read what the theory of the case was for your client, it seemed to me it didn't prevent your client from making any argument. It didn't change the relevant evidence. The theory was whether he actually declared the chemicals, and if not, did so knowingly that they had not been declared or with intent to defraud. That was the theory. I don't see how it got any change.
Defense counsel asked the jury 8 times in closing arguments, were these the actions of a smuggler? The government responded by saying, yes, these were the actions of a smuggler. This was hiding. This was not just failing to declare. It was a hiding. They said that 7 times in their closing argument. And that's the prejudice. And the jury thought really hard about this case. They were conflicted about this case as to whether Ms. Perez even failed to declare. But they were not ever, in response to their jury note, they were told, don't worry about the smuggling, focus on the failing to declare. And even with that component of the first element of 545 off the table, they still did not convict Ms. Perez as to a number of the pesticides charged.
So I'm just going to say right now, I think she's not doing well. And I'm going to tell you why I think she's losing. So we've got one justice here who is, so guy on the left is giving her a lot of grief. And he's basically just trying to get her to concede her point, right? That's really his goal. Guy in the center, you can see he's got his arms folded. He's not really engaging with her. He's not really having much of a dialogue there. He's not saying anything. The justices that are dangerous are often the ones that aren't talking, because if they're talking, then at least you can change their mind. Sometimes if you've got a justice who's not asking any questions, it's because they've already just decided that your argument is crap and unsalvageable. And I think that's where she might be, especially because if we look at dude on the right hasn't even looked at her that I've seen. He's on his computer. He's doing something. He's reading that, but he's not really engaging with her in any sense. So I think that's a concern here. And I see why am I doing body language analysis? You always have to ask yourself who's paying attention. There's no like magic to this, but it is concerning if you're not, if you're not having the panel engage you. That's something that worries me if I'm there. We are covering more than one case. There's a Pew Pew ad ban that comes after this. So, yeah. All right, let's keep going.
Seems to me then that the jury seemed to understand the very point you're making.
Your
Only
Honor,
found her guilty of the rat poison.
so the jury wrote in their second question to the court, if hypothetically we thought she failed to declare some goods but not others, what should we do? And the jury told us exactly how they were thinking, because that's what they did. They focused on the failure to declare, not the smuggling, not the hiding. I'll say the statute would be incredibly broad without the two guardrails Congress put in. One is the smuggling, the act of hiding, and the other is the intent to defraud. Taking those out, the millions of people crossing the border with Mexico and the U.S. every day would be subject to this incredibly broad criminal statute. But if this court doesn't have any further questions, I'd be happy to move on to the restitution issue.
So just to be clear.
If the court doesn't have any other questions, I'd be happy to move on. She's like, she's not conceding the point. That's a good thing. And that thing about saying that if the court doesn't have any more questions, she's feeding the court. Like, you don't have any more questions. I want to move on. And so what she's trying to do here is time management. And she really wants to get to this restitution point because she might have some better arguments there, or just you don't want to lose on restitution having never actually argued the point. So, yeah. But we're actually going to hear from this guy on the right, it looks like.
Your argument is that smuggling is not failure to declare because smuggling includes failure to declare you could do accidentally, right? You just forget, where smuggling includes a knowing element. Is that?
Well, the statute does already have that knowing element separately, but it includes a hiding, includes an act, a hiding. So here's an example.
So you're.
Now, I actually think guy on the right is doing her a tremendous favor here. He's not convinced, right? He's not. I don't even know if he necessarily understands her argument at this point, because she's maybe not doing the best job of articulating it. So he's saying, whoa, you want to move on? Let me drag you back to where you're floundering. That's probably doing him a favor. Generally, I want when you're going into appeals, generally you want to have done good work in your writing. And then from there, you want them to ask you the questions as to where they think you need to shore things up. Steering them to where you think you're best may not actually be a good idea sometimes, because they're like, yeah, we agree with you. That part is good, but you're going to lose on the other part. So
It seems to me the knowing would include the hiding, but where would the knowing not include? Is it, so you failed to declare, let's say, and you knew that you were supposed to.
Yeah.
Because you're thinking you forgot? Like you knew, but you forgot? Is that?
Here's a helpful example, I think. So I go to Mexico, I buy a new shirt. I put it in my suitcase, where shirts go.
So you go to Mexico and what?
I buy a shirt.
Shirt, okay.
Yeah, nice Mexican shirt. I put it in my suitcase, which is where shirts go, and I drive up to the border. At the border, I see the sign that says, you got to declare all goods you bought in Mexico. And I say, I don't have time. I have to get to work. I have to get home. So I knowingly fail to declare, but I'm not smuggling, I'm not hiding. The shirt's in my suitcase where shirts go. If I had like cut a hole in the seat and put the shirt in there, that's definitely smuggling. That's that act element.
But isn't there another element that says the intent to defraud the United States, so that sweeps that in?
Yeah, but the
Now she's got at least all three of the justices are now engaged, but I think that they're all kind of skeptical. I don't think that argument went over well, and it was a little weird. That whole thing of like she said, "Where shirts go" repeatedly. I would have just said, she puts it in her suitcase. There's no intent to hide because obviously they're going to check the suitcase. That's an obvious place. It's not a concealed place. It's not a secretive place. It's just the place things go. But I don't, examples are dangerous because I think in this example, she just convinced them that she was talking about smuggling. And I think that that's why the justices are sitting up and taking notice is like, whoa, wait a minute. That's your example? Not a great place to be, but I think she was up against it before she walked in. I suspect that she was having some trouble with her brief.
shirt could still be in my suitcase with the intent to defraud, intent to deceive. I'm going up and saying, I know I should declare this, but I got to get home. The smuggling narrows the act to an act of hiding. And I think what's important here.
I mean, I guess I'm not trying to fight your hypothetical, but like it seems to me like you could actually just put it in your suitcase and meet all the elements, but you just hope that they wouldn't, they don't normally search all the suitcases, right? So you're just hoping you can kind of get away. So it's not clear to me. I guess I'm not finding your example real helpful. It is true you have to have.
I'm not finding your example real helpful. Yeah, he's basically saying your example may have been stepping in it a little bit here. He says, the justices, I think, are saying, this sounds like smuggling to me. How is this not smuggling?
All these things, but I thought the court's answer, I'm trying to figure out, it sounds like your disagreement with the court's answer was literally like the word no at the beginning. Because, it says, is smuggling the same thing as failure to declare? And you think the answer to that, or is there a distinction? You think the answer to that should be yes?
Yes, I think the
but
answer.
Other than that, it doesn't seem, I'm trying to figure out where the error is other than that, because if you continue reading, you don't even have to go to the instruction, but it says fair to declare, knowing and willful with intent to defraud.
But it doesn't include the act of smuggling. And this court's jury instructions do include.
Okay, but if somebody's.
You know what I might have done to change up this example? If you had to use this example, and I don't think this is example time, but if you had to use the example, I would have said she goes to Mexico. She buys a bright Mexican shirt. She puts that shirt on her body and she walks up to the people, and they ask her if she has anything to declare. And she says no, but the shirt is not hidden. It's not concealed in any way because it's on her body. They can literally see it as they're looking at her. I think that might have helped their example. Because this, I think that this example has actually moved the court away from her, which is not where you want to be with your examples. Yeah.
I was asking if two things are the same thing, and you say that they are the same thing. And one of those things, it does include the act of smuggling.
They're not the same thing, to be clear.
No, I know, but if the judge wrongly said, in your view, that they're the same thing, then by definition, it does also include the act of smuggling, because you're saying they're the same thing.
I understand your Honor's point.
Yeah.
They are two different acts. The smuggling is an act of hiding. The failure to declare isn't saying anything. And those two things are both in this court's model jury instructions. They're in the statute as separate components, and they're in the instructions here.
I guess I'm.
And they are.
The court really doesn't like this because it's an example of, like, her example is somebody who is trying to, lying to customs to defraud customs, and they're doing it because they're in a hurry. But yeah, it's not a good example. And And I can tell you, when I go through customs, I am like, hey, let me tell you every little thing I bought. I have a pack of gum in my left pocket. It is, I got this from there. I have the receipt. I have when I went to Texas, I bought some candies. Uncivil will remember this. We went and stopped at a place and I bought some candies. I declared the candies. I declared everything I got, because why would you not, why would you want to mess with customs there? All right.
I understand that argument. And so that you could fail to declare innocently, so to speak, right? You just forget, right? That you, or maybe, maybe there's other ways. But if that's the argument, then why does not the rest of the answer, without even having to go to the jury, why does not the rest of the answer resolve that? But if the argument is, and you seem to be making two arguments, but they seem to be kind of inconsistent to me, because the other argument is, yeah, but smuggling and the judge was just wrong. They're not exactly the same thing, and you have to, and the smuggling element is missing from the rest of that stuff. But it's actually saying they're the same thing. So how is the smuggling element missing? It's built into the fact that he's, in your view, wrongly saying it's the same thing.
Now, I mean, the argument she should be trying to bring them back to here is, listen, they say you have to do one thing and the second thing. Those things cannot be interpreted as the same, as being the same. They have to be different things, because otherwise they'd have just said failure to declare, we're done. So then you say smuggling itself has to be an additional behavior. They're trying to criminalize the heightened level of responsibility that comes in the same way. I mean, the example here I might give is a sentencing example. The sentencing example is, so let's say you're caught shoplifting. You walk into a store and you walk out with a pen in your pocket. You will get whatever sentence for this. But if you have a specially designed bag that is designed to conceal this pen and to prevent those, the safety, what do you call it? Those anti-theft archways, the alarms, from detecting it. And people make these special sort of thieving bags. That gets you an additional sentence, because that's way worse that you were planning that. This is what I think I might be arguing and saying, hey, I think this is the issue. I don't think she's going to win.
I think because failing to declare doesn't involve an act of hiding.
It says failure to declare, knowing, and acting willfully. I mean, those three things together would seem to involve hiding, right?
I don't think so, and I think more importantly, whatever exactly smuggling means, it's in the statute. It's in this court's model instructions. It's important that the jury find every single element and every component of that element. And by taking that off the table, I think that's real erroneous. I see I'm running low on time, and I do want to get to restitution, and I want to answer your questions about that. So I think the restitution here has a lot of problems, and the main.
What's the standard of review for me in looking at this restitution order?
De novo on the law for whether he got the law right.
So what he's asking about standard review is basically, how wrong does the court below have to be in order for them to flip that decision? So there's different standards of review, and de novo is a really good standard of review from her position, because it's basically, if you guys disagree, then you can reverse. But there's much stricter standards of review where the court can say, listen, we think the lower court got it wrong, but not wrong enough to change the decision. Standard review is really boring. People hate putting it in their legal briefs. People hate discussing it. Cases are won and lost on standard review. Get good at standard of review arguments if you are a lawyer, because often there's nothing to argue, but if there is something to argue on standard of review, I have literally seen cases where they say, listen, I saw one where somebody conceded the standard of review argument and probably shouldn't have. And then ultimately the court said, I am going to rule against you on this standard of review, but I would have ruled for you on this other standard of review. And you feel bad. So yeah, that's what they're asking about right here.
And that's
So,
our
De
argument.
novo on whether it was caused.
Correct. De novo on whether this was a cost of
And
prosecution.
after that, if it has nothing to do with caused, but we're talking just simply about the calculation of the restitution, at that point, given that there was no objection, it's plain error, right?
We disagree in our briefing, but I think more importantly, it would be
Well,
plain
Well,
error.
I was going to say, you may disagree in your briefing, but it is plain error if you're not.
I want to
gonna
focus on the fact that it would be plain error, and that's because
So she's just made a concession. It's a reasonable concession because it looks like the court was. This is what Uncivil was talking about sometimes you can lose things by failing to make the concession. She was not going to win this argument, and she did well by just dropping it. Hopefully Uncivil agrees with me here.
in Tsosi and Wakneen, this court made clear that if you're going to go with an estimate, not even an actual loss, you got to be real sure, you got to be formal about it, and an email estimate is not enough.
Well, I'm not sure. It seems to me that in Doe, we said, we will uphold an award of restitution if the district court is able to estimate, based on the facts in the record, the amount of the victim's loss with reasonable certainty.
Right, and here,
You're saying that on plain error review, I can't find there was reasonable certainty on this estimation?
So here's the issue here is that so the estimation aspect, the government wants $13,000 from her client. She doesn't want to pay $13,000. And so one of the complaints here is that this $13,000 isn't the cost that they spent. It's an estimate, right? So let's say you take your car to, let's say you take your car to a mechanic, and he looks at the car and says, I estimate this is going to take $3,000 to fix. And you go, okay, we'll do it. And later it comes back and it cost $5,000. Or maybe your mechanic is like, hey, I thought it was going to be $3,000. Turns out I just had to prod some things, and I knocked some dirt free, and it's good to go. That's going to cost you $500. I had that with at a similar situation when I thought my furnace was failed. I thought my furnace was dead and gone, and the guy came in and was like, oh no, turns out this thing has a fuse in it. And, I didn't know there was a fuse in it. And he's like, yeah, I swapped that out. You're good to go. Turned like a several $1,000 visit into like a $250 visit. She's saying, listen, all they have is an estimate. Why should I have to pay for this estimate? Like, why should you order a restitution thing based on this estimate when it could be wrong, when they haven't actually incurred that cost at this point? So, and whoops, Mike S., I see, hey, me and my girlfriend met you at the DEP trials. That's awesome. That was a long time ago, but that was a weird time. I will say, during most of the DEP trials, I was so exhausted that I was barely thinking. So I hope I was not a jerk.
that's what this court did in Nicolene, in a
I
published case.
understand what they did there, but I don't think that case at all resembles the facts in this case.
So a court can estimate, but it's got to do that based on
Well, that is an
receipts.
estimate, and it was supplied by a person who could estimate. And that court looked at it and said, well, okay, with reasonable certainty, I guess I can put that on there. And I'm now on plain error review. I appreciate you may want me to second guess and say what I think, but that isn't plain error review.
Your Honor, this court has
So this is, again, a standard review issue here. He's saying that this is plain error review, which means it's more than just he disagrees. It's got to be that the error, like that this was plainly wrong, basically, at the previous court level. And he's saying that's not the case. Now, I'm just going to note here that when we say the standard review is a big deal, this is what they're fighting over. And here, he's really not liking this idea that an estimate isn't good enough. He really does not like that argument at all.
As found otherwise, and I want to be
All the cases your cite for otherwise do not represent the facts here.
okay. I understand your disagreement. I'd like to.
Ooh, she's not doing well. That justice just called bullshit. That's really what that was. He's just like, the cases you're citing have nothing to do with this. That's the justice. He could literally have just said, bullshit, right? That's, and all she can do in response to it is to just say, I understand your disagreement, because you're not fixing this, right? He's not. This is the place where you are in real soup, because he's not saying, can you tell me how this case is on point? He's not asking her to fix it. He's just telling her, you're wrong. Like, this is not, he's not even giving her an opportunity to save it. So, yeah, that's a bad place to be. And Fast Group, I see USSL FFL manufacturer and firearms instructor here. Awesome. That is pretty cool. So I see people commenting about she can't grasp her arguments with her tiny T-Rex arms. One of the things that's very difficult in these circumstances is, what do you do with your hands? Because, you have to do something with them, and it's really easy for your hands to end up being distracting. What sometimes I've seen is lawyers who stick their hands in their pockets, and this is a very bad move if you're a guy, especially if you're a guy who is the habit of like playing with your change or playing with your keys. Because I can tell you what playing with your change in your pockets looks like from the bench. And it's real bad. It's so I'll tell you what my strategy is on that. Fast Group, I am sorry if I missed that, because shoot me another message. I just get lost in stuff. I don't mean anything by it. I just get lost. But yeah, it looks like pocket pool. You don't want to be playing pocket pool in court. You don't want to be seen to be playing pocket pool in court. You also don't want to be doing stuff like, I watched a guy in the Court of Appeal with a pen, and he was clicking his pen every time he got nervous. Click, 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 click. And it was freaking annoying. I wanted to walk up there and slap him. And the justices, you could just tell that they were getting that they were twitching. Shoot me a Twitter DM. I will try to get on that. So don't bring a clicky pen. Like, this pen does not click. It's a great pen for this. So, yeah, it's just, don't do that. I often, and I know this sounds terrible, my strategy is often to just hold on to the desk and grip the desk. Gripping the desk makes you look like you're confident. It makes you look like you're strong, like you know what you're doing. And often you're just holding on for dear life and holding on to, to keep your arms from doing anything else. So, yeah, but the T-Rex arms, I don't think the justices are really seeing it as T-Rex arms, but maybe. Anytime you have a personal, twitch or habit or anything like that they are that they're noticing, that's a bad place to be.
Reserve the remainder of my time for rebuttal unless this court has any final questions.
I'd like you to, so that the government can respond, I'd like you to think about.
I'd like to reserve some time for rebuttal, so they want to respond to they want to save some time because they know the government's going to make points and they want to respond to those. And this justice is like, nah, you're not getting out that easy. We want to, I got more questions. So she's stuck. We'll see that one of the justices is gonna help her out there.
Yeah, the only thing I can really talk about with where I have to make the decision, the cause. How can you say that taking this, if you will, these illegal drugs and disposing them was not caused by her?
I'll say they're pesticides, not drugs.
Okay, I'm just trying to say they're illegal.
Okay, all right, yeah. I don't know how you can say this cost was caused by Ms. Perez rather than
How
the
can you
EPA's.
not say it wasn't? I mean, she brought it.
So the EPA has
It isn't a matter that she didn't bring it. They had, on them finding it, they had to take it, and they had to destroy it.
So they didn't have to. The standard process under their own regulations is that they have to offer the importer between 30 and 90 days to make a choice about what to do with pesticides that are not allowed into the United States. The importer's choice can be to export those pesticides back to Mexico at no cost to the government. And the government, in its briefing, says that the only reason they give for holding on to the pesticides is to prosecute Ms. Perez, which of course they can do.
Yeah.
But
This is a better argument. She's onto a better place here. So what he's saying is, like, why isn't this $13,000 her fault? She brought these poisons to the border. And her response is, listen, the EPA rules that she was violating actually say that these poisons can be sent back. Like, we could just throw them across the border back into Mexico and everything's, solved. And sending them back into Mexico doesn't cost $13,000. Like, that's nothing. So she shouldn't have to pay the $13,000 just because they decided to keep hold of it. So I actually think this is a stronger argument, but he doesn't like it. He says, well, they're seizing it for evidence. They're going to have to destroy it. I kind of lean on her side on this.
this court in Salcedo Lopez made very clear the cost of prosecution can't form the basis of a restitution order. I see I'm very much out of time, so.
Give you another 2 minutes for
Okay,
rebuttal.
thank you, Your Honor.
That justice did her a solid, because she's like, I got to get out of here. I am, I know I'm losing. Please just let me off the line. Please let me off this hook. I am like, I'm done. I want out. And, but she's out of time. So technically after the other side does their argument, she doesn't have anything for rebuttal. That justice was like, you wanted to stop talking. You got dragged in. I'm going to give you 2 free minutes. Now, 2 minutes is not a lot of time, right? Many people spend longer than 2 minutes in the toilet. Probably the guy on the left, certainly. So, you just got to, she's not going to have a whole lot of time to deal with anything that comes up. All right, so now we've got the lawyer.
Good morning,
for the
Your
United
Honors.
States.
May it please the Court. Jacqueline Stahl for the United States. Picking up where my colleague left off, this was absolutely...
Actually, let's take a minute here. I'm going to cover some of the, the super chats and so forth while we've got a second here. Let's see. All right. Cassie, thank you for 1 gifted membership. Nicholas Staro's Trial Watch, thank you for the member chat, saying parts of my barn are not lit, but kind of far away. Yeah, a little farther away than, say, my local forest, definitely. A Capitan, thank you for 5 gifted memberships. Much appreciated. Vez from Quebec, is the party's time stopped when the justice is asking questions or just gone? We answered that. It is gone. Hi, Ian. Gosney mentioned those spicy noodles. Boldak 2 times spicy chicken ramen could be had at Superstore. Pretty cheap. They're delicious, but very hot. I have to make a Superstore run later. That sounds amazing. Hey, me and my girlfriend, I covered this, met you at the Johnny Depp trials. That was a weird experience, but glad to have met you. Suzanne S., happy Wednesday. Thank you very much. Dayslav Act Mandan Carey, keep fighting indeed. Thank you. All right. So, May It Please the Court is the sequel to Ian's legal porn film, comes now. May It Please the Court is one that you sometimes have to use. Like, if it pleases the court, I'm going to do something that, it's kind of you're asking permission. It's like, you're saying, excuse me. So, yeah. DSN, thank you very much. Much appreciated. And I see, what is it? My husband grew Carolina Reapers. How's the hot sauce? The hot sauce is good. I got to get it ready to ship. All right, let's keep going here.
Caused by Perez's conduct. As the district court explained, it is undisputed
Is
that
this an actual, when you say it's cost, is it an actual cost? This was an estimate.
She didn't get 30 seconds in. Remember how I was talking about how you only have a limited amount of time before you, before they interrupt you and start taking you into their case? She didn't get 30 seconds in. She doesn't get any speech whatsoever. So, yeah.
Right?
as to the amount,
Yeah,
yes, it was an estimate from the contractor.
So
that-
hard to say an estimate was caused, I feel like, saying like,
The cost of, I understand, I
Yeah.
apologize for the confusion. The cost of disposing of this hazardous
if
waste,
the estimate was true and it actually had happened, then it would have been cost, is what you're trying to explain. But we don't even actually really know that how much the government actually spent, right?
Did you hear him say, because that's what you're trying to spin? Ooh, I don't like, if I'm her, I don't like that she just said what you're trying to spin. That's a hard comment to come back from. That's gotta hurt. So he's basically saying, how's there any cost here? If you how do we say this is the cost if it's just an estimate? And she's going to end up with some difficult circumstances here. Joe Loy is saying, I'm not sure her jumping in was a good idea. I think that she did exactly what she should be doing here, which is that she's jumping to the weakest point in her argument. And I think that's where you want to tackle things head on if you can. And T-Rex is nothing compared to the Valley nasal speak. I know my voice is not necessarily the most pleasing thing at all times, so I have a hard time judging, but she was grating on me a bit.
is the government still holding the pesticides as evidence because this is an ongoing case, an ongoing
Also, it hasn't
appeal?
disposed of them yet. Okay.
Correct, Your Honor. I think what's important to remember here is that this was a criminal case. So my colleague mentions the CFR. When someone tries to legally import pesticides, they have to file a notice of arrival. The EPA has the chance to decide whether these can come in. And then the EPA, if they say no, allows the exporter to remove them from the country legally. Perez's conduct took this into the criminal code, the United States Code. The government seized these items as part of a crime, and whether or not she was prosecuted, the government had to dispose of this hazardous waste.
Suppose.
So you can see her argument here, but she's going to run into some problems with tenses, and this is going to cause some issues for her later. Because she said the government had to dispose of this. Remember that she said the government had to dispose of this.
That she brought these pesticides to the border, and the border agent asked, do you have anything to declare? And she shows the pesticides, and here, I'm going to go home and use them. And the border agent looks at it and says, no, you can't import these to the United States, takes them away, and then has to dispose of them. Could the United States then seek restitution from her for the cost of disposing of them?
Because she declared it, then that would take this out of the criminal context. She wouldn't have been convicted, so there wouldn't be something to tie the restitution.
I guess, but in this case, the jury has this kind of odd, response in the jury verdict form where they say, we find her guilty of The ones that maybe she didn't declare and she kind of tried to hide in her purse, but the later ones where she said, yes, I have additional materials in the back of my car, it seems like the jury said, no, that was not, she was not guilty of that offense. So with respect to those later items, I mean, can the government seek restitution for those?
Yes, Your Honor, because this was a one-count indictment. So there was only one count of conviction, so the jury's note doesn't have any legal effect with respect to whether or not she's been convicted. And as the district court explained, it's undisputed that all these items were in the car. And
This, I think, is not her best argument. It's a one count indictment. We rolled everything into one count, and it's like, well, that was your call. I think the justices are skeptical on the amount. So yeah, I think the justices are going to be very skeptical here. So yeah,
so here, giving restitution for the full amount is
I'll
appropriate.
let you know.
If we look at the jury's
once
note,
it's available.
it's also clear that they weren't grappling with whether she smuggled, whether these were hidden. The rat poison was hidden in her purse. The other pesticides were hidden in a secret compartment behind her daughter. These were surreptitiously hidden.
But she did declare them when they asked. I mean, the first one, she tried to, deny it, and then afterwards, the agent asked, well, do you have anything else to declare? And she says, yes, it's in the back of my car. So it seems like the jury said the first one, yes, guilty, and the government can seek restitution for getting rid of those. But the others in which the jury said no, I mean, it seems like that wasn't the criminal conduct according to the jury.
The government wishes we had done a better job arguing and closing that it was the failure to declare at primary.
Yeah, this is not a good argument because you didn't. Like, you don't get to relitigate it on the basis of, if we sucked less at trial, we would have won this point, because you did suck at trial and you didn't get that, so you don't get to relitigate it. Yeah, uncivil, that was the wrong answer. It's so the wrong answer. We wish we hadn't sucked at trial. Like, everyone wishes they hadn't sucked at trial if you don't get everything you wanted, but it's happened. You don't get to relitigate the trial at this point. So, that was, I don't know what she's thinking.
So I think that would have cleared up some of that confusion for the jury. But even taking, I go back to the fact that there was one count of conviction, and that the judge found that all of this was related to that one count of conviction. She smuggled in.
So even if, say, there was no disposal cost for, instead of being two different types of pesticides, or like rat poison and whatever they were, there are two different types. But like the first one, the one that the jury was clear, we convicted her of something that had no cost for the government to dispose of. Say it's gold, it's valuable, I don't know, and the second one is, say it was cash, like a bunch of money. And the other one, so it has no cost for the government to dispose of. And if they made that clear, you would still say that they had, that the fact that we're going to have to spend money on the thing that the jury did not convict her of smuggling.
545 also allows for forfeiture, so if it was gold or money, the government would have included.
My point isn't, don't get caught up in the gold. That's just to show that, like, if they convicted her of something that had no cost to it, you would say, and all of the cost, the $13,000, was attributable to the item that we know the jury did not convict her of actually trying to smuggle. You would still say that she should have to still have to pay for that?
It seems from your hypothetical, there would have to be two different counts. If we're
Because
talking,
it says just assume, stop fighting hypothetical. Assume there's one.
Stop fighting the hypothetical. That's exactly what I was thinking this whole way through. Is so the justice is giving her a hypothetical scenario, and the reason why he's doing that is he wants to test her logic, right? He wants to say, does your logic hold up, and do you agree with the underlying principles of your argument? And she's going, well, that would be a different scenario. Like, it would change these following things. And he's like, stop it. Just answer the bloody question, because I actually just want to see if your logic is good. And that also kind of tells the justice that her logic is not good, because if her logic was good, she wouldn't need to do this. She would be able to just engage with it as she goes. But nope. And somebody was asking, what kind of pesticides were these? Well, I looked that up. The person who's appealing in this, Veronica Perez, got 60 days in jail after she was convicted. She had concealed 20-carat containers of zinc phosphide in her purse and had failed to declare them. Now, that stuff, a consumption of a single pellet can be lethal to a small bird or mammal, and ingestion of a teaspoon of it would likely kill a 150-pound person. She also had Cufuran and Metaldane in her vehicle. Cufuran is what is it? It's toxicity category 1. It is lethal on ingestion, contact with skin, and inhalation. And Metaldane is also acutely toxic and basically causes a whole bunch of problems, polluting streams and killing animals when spread around onto in areas. No, 20 containers. I don't think it was 20 kilos. I'm just trying to see if they have the. They say 20 containers, but I mean, it wouldn't be 20 kilos because she's smuggling them in her purse. So 20 kilos would have been, that's a big purse. So it's just 20 containers. I'm guessing the containers are pretty small.
Count and it was gold pesticide. All right, that's really valuable pesticide, but it doesn't have any cost to dispose of it for whatever reason. And so we know that all of the disposal costs are for the thing that the jury made clear she was not convicted of. I don't sure that one count would mean that she should suffer, especially under the standard for restitution. The standard for restitution is the government has to show that it's actually going to experience these costs, and we don't know. We don't know how much of the costs are attributable to the one.
If I'm understanding that hypothetical correctly, it's that you're saying they're all one count, but for example, the rat poison here didn't cost any money to dispose of, and the other pesticides did.
All the cost was attributable to that, then would you still be able to get restitution for something that she was not convicted of actually smuggling?
Yes, Your Honor, because all of these were included in her car. As the district court explained, now the government has a duty and obligation to.
So look at their faces. Guy on the right is giving her the what the heck. Guy in the middle is leaning forward, and the sort of grumpy guy is just leaning way back. Grumpy guy wants to, he likes the original verdict. I think that's fairly clear. But I don't think anybody is liking this answer. I don't think anybody is thrilled with this particular response here.
Dispose of them, and it was a direct result of her conduct.
Let me go at this a little bit different. Again, that's why I started out with the standard of review. It seemed to me that if we find that it was caused, and if the statute suggests cause, and the case law suggests cause, it wouldn't matter after that what was disposed of or what wasn't to us. If we're only on plain error review, we would only be able to say, did the court plainly err in what they suggested? If the cause meets the statute, that's the only place we can stick our nose in, if you will. We're only there for the legality, the cause. After that, it's an abuse of discretion what the judge did, but in this instance, it's not even that. It's plain error review. Isn't that the way we have to look at this?
Yes.
So this guy, you can tell, really wants the U.S. to win on this one. And he's like, your argument sucks. Isn't this a better argument, this one I'm feeding you right now? Because you're totally pooching it right here. And let me tell you what you should be saying if you were doing a better job. Yeah. Yeah. I don't like this. I mean, sometimes it helps when you like, it really sucks if you're the other side and you're seeing the justice like feeding them an answer. Yeah. Somebody's asking why are the people smuggling pesticide? Well, the article that I'm looking at, which is actually a release from the U.S. Attorney's Office, they're basically suggesting that illegal cannabis growers in the states like these illegal pesticides because then they can use them on their cannabis fields, and that it's causing harm to people who are to like government agents who are um, clearing these illegal cannabis fields. So that's what part of this is about. That's why they're so pissed.
Your Honor, I agree with that. And maybe the Phillips case is instructive here regarding the cause issue. In that case, it was an environmental spill. There was investigatory and cleanup costs. And this court explained that because it's not a normal part of the prosecution costs, if it's a direct and foreseeable result of the defendant's conduct, then that is entitled to restitution.
Maybe, this kind of, I think relates to Judge Smith's question and my question, because it kind of is a cause issue. What I'm trying to get at is a cause issue. Let's say she drove up and they said, and they asked her, and she did declare some stuff. They said, whoa, you can't bring that. That's completely forbidden. And so they take it from her. But I think, as we said earlier, she wouldn't have to pay any restitution cash for that stuff they took. But then turns out that there's something she didn't declare, and they take that from her, but that thing doesn't have any disposal costs, which seems to me is kind of how we ended up, given what the jury wrote on its, it just happened in the other order, according to the jury. Right or wrong, I understand that you don't agree with the jury, but right or wrong, that seems to what the jury was basically thought she declared some of it, and she didn't.
I understand you don't agree with the jury. That's not where you want to be, right? Because this isn't the place for disagreeing with the jury, unless the jury somehow made some sort of egregious error. This justice is basically like, yeah, slow your roll here. I think the government's going to get some of its money, but I don't think all of it. I think we're going to see. I'll give you my prediction at the end of this one as to where we're going, but I think the government's going to get less money than they'd like.
Declare other. But under the hypothetical I'm giving, where she declared that stuff, could they charge her on the restitution for the stuff that she had declared? Could you charge her for restitution? To use what Judge Smith's talking about, would you say that caused the cost?
I apologize. I'm not sure I'm following. So
So you declare half the stuff, and they take it. They take it because it's not allowed. Mm-hmm. And then, but they also catch you in some other stuff, which they take, but has no cost to actually dispose of that stuff for whatever reason.
And are charges brought to the
Your charge is brought on the second.
Okay.
You convict her, and then you try to get restitution for all of it, excluding the stuff she declared.
That would be appropriate, Your Honor.
That would be appropriate.
Yes.
Okay, it seems to me like that would have to be under your argument, because essentially what happened here, it just happened the other way around, according to the jury. The jury thought that but why would that be appropriate?
If I may interject, and you could answer it. It basically seems, the nub of it seems to be the government is trying to seek restitution for non-criminal conduct found by the jury. And and regardless of the standard review, I think that just seems error for the government to seek restitution for something the jury said that is not criminal.
So right now we're seeing the court. We've got two justices who are basically calling BS on her notion that they can get restitution for the non-criminal aspects. And guy on the left here is saying, hey, sure, it might be a mistake, but it's not enough of a mistake, so we should let them keep their restitution, right? Yes, this is Veronica Perez. So, yeah. So, not enough of a mistake, so they should keep their money. We're seeing the makings of a 2-3 split on this, or a 2-1 split on this one.
But the jury did find it criminal. The jury found
for the one of it, I understand that act of the pesticides, but the rest, they said it's not criminal, yet the government's trying to seek costs for both of them. And that's the one that I find baffling.
But the indictment reads, the importation of merchandise, Mexican pesticides, to wit, and then includes a descriptor. The
That was an
government,
indictment, but the government didn't prove it. The government lost. I mean, the government can indict someone for all these things. If they don't prove it, they lost. And
You lost. Quit trying to spin it into a win. You lost. Yeah. That's not. She's not in a happy place. This is not her happy place.
juries, that's not criminal.
Well, that's why I'm asking you the hypothetical, because, I mean, you're saying, you're on one hand, you're arguing, and I understand that, no, it covers it all because it's one indictment. That's why I asked you the hypothetical, because if she had declared, I don't think you could have that argument that, like, that the stuff that she had declared. So if we were to conclude, contrary to what you're saying, that like some of these pesticides, she was not convicted of smuggling. And so that's my hypothetical, that she, like, let's assume she just voluntarily declared them. But you just said that even so, they would be able to charge her. I think your argument is because she was convicted of other stuff, even though the other stuff say there was no cost to. Why would they be able to do that?
because it was all part of one incident. So for example, the case involving the spike strips and the damage to the car, the Alvarez case, this was a transportation of aliens case. Border Patrol, intervening cause, put out spike strips, and it destroyed the car. Then the rental company was entitled to restitution for that. That wasn't a cause. I mean, you could argue under your hypothetical, that wasn't criminal conduct that the defendant engaged in. She didn't crash the car, but her criminal conduct was transporting aliens, and that led to the destruction of the car. Here, her criminal conduct was importing Mexican pesticides, which is hazardous waste, which the government, whether or not they prosecuted, would have had to pay. So here, it's not the fact that what she was convicted of or not, it's that she brought in illegal pesticides, she was convicted of that crime, and the government is now on the hook for disposing of that hazardous waste. So maybe expanding on your hypothetical.
Whoops. I just Elaine that. Sorry, I was messing with my mic. That was a bad place on that because like she finishes talking and the justices just stare back at her and there's no response from the justices. They just stare there. Oh, is it judge? Fair enough. In Canada, it'd be they'd be justices, but if it's judge, that's fine. So yeah, they just stare back, and hopefully you guys are getting audio at this point. So they're just staring at her like, yeah, that was a lot of words you just said. Are you done? Are you finished? So that's a flop.
If at primary she had declared these pesticides and said, I have these pesticides in my car, and the CBP officer said, you can't bring those in, CBP officers turn people back around. You can't bring those in. Go out.
Let's assume that they just took them. I mean, I understand, because then there would be no cost, I suppose, under that hypothetical. Let's just assume they took them. I still not, I'm not following the idea that, like, if there was, thousands and thousands of things that were declared, and it turns out that, using that there's like one fell in the, or one is in the back or something, or one's in her purse. And somehow you're saying, well, the fact that she didn't declare one of them means that all the other stuff that she declared and got taken away, and they wouldn't normally be able to get restitution. Now they get restitution for all of it because because her illegal conduct caused them to take. But I don't see how her illegal conduct caused the vast majority in this hypothetical of the cost. And if that's true, then in this case, since we don't know how much of this 13,000 is for both, is for all of it, right?
So somebody's asking, is this how all appeals courts? Seems very tough. This is actually a good appellate bench. And what I mean by that is that you want the judges to be asking you, you want them to be asking you questions. One of the worst places to be is for you to be sitting there in front of the panel, and the panel just has nothing to say to you. And one of the harshest losses of the Crown that I've seen was a situation where so they get up and they just stand up, they make their arguments for they use their entire time. The justices asked no questions whatsoever, like not one. And they finished talking, and the justices said, do you have anything else you want to say? And they said, do you have any questions? And the justices said, no, we don't. And the Crown said, okay, we're done. We're good. And the end of that was that the justices turned to me and said, Mr. Runkle, we don't need to hear from you. You're they ruled in my favor without hearing from me. So that, I think, is that was a bad place for them to be. So, yep, that's not a good spot. All right, let's keep going.
Know that the rat poison in her purse that she was convicted of is the $9,000. So it is the bulk of the cost because it's poison. So it has to be incinerated under very strict limitations. For example, in the PSR, the agent explained why it was so dangerous she had it in her purse was moisture from your hands could have gotten trapped in the purse, could have activated the rat poison, creating a deadly gas and killing her and her daughter. So the $9,000 is for the more poisonous substance that was in her car. But she was smuggling Mexican pesticides. It was one crime. It was all of the pesticides that were not allowed to be brought in. It was undisputed that she didn't file a notice of arrival for any of that. And for restitution purposes, the standard is preponderance of the evidence, and then how to prove the amount is reliability. Here, there is nothing unreliable about the government's estimation, and by a preponderance of the evidence, the district court appropriately found that it's undisputed all of this was in the car, that it's undisputed the government now has an obligation to dispose of this hazardous waste, and it is undisputed that this was caused because of her conduct, bringing this into the country.
Just one clarifying question. You said that the materials have not been destroyed yet?
Correct, Your Honor.
Okay, great, thank you.
That's a problem, right? There's because remember how she said that the government has incurred this cost of $13,000. They haven't incurred the cost yet. They haven't destroyed the stuff. They still have it. So when she said that they had incurred the cost, that was misspeaking. And now, so they want money that they haven't spent yet. That's potentially going to be a problem for them. I'm seeing people saying my mic. Can you hear me? Hopefully people can hear me. Okay, let's keep going.
Attempt to keep all evidence until a conviction is final after appeal. Unless the...
Yeah. So as I understood it, the estimate is what the cost would be once destruction was happened.
Yes, Your Honor. If the court has no further questions, the United States respectfully requests that this court affirm.
Great, thank you.
So that's basically saying if you have no questions, we're asking you that we should win, and I'm going to sit down now. So yeah, fair enough.
Could you address that she said that the 13,000 can be split, or can you address that? Is that, do you agree with that? Or
Yeah, so the Supreme Court in Huey made clear that the specific conduct that's the basis for the offense is what forms the basis of restitution. So I think here the jury made pretty clear what they thought the specific conduct that was the basis of the offense.
Well, that depends on whether you take your idea of what the basis of the offense was or what they were charged of. the jury found your client guilty.
As
They
to,
just didn't think that your client was guilty of all the things the government thought, but she was nonetheless guilty of one count. And as a result of her coming to the border with all of that stuff, the government has to destroy it.
I think this
If
is,
she would have come and declared it all, she'd have a different view, but she didn't.
so the Supreme Court took a different approach in Huey and said
Well, I
this,
looked at Hubie, and I don't believe that. Why is Hubie different?
because Huey made clear it's the specific conduct that is the basis of the offense.
I understand.
And
the
so,
specific conduct here is how you label the specific conduct. You just want to label it that conduct about that rat poison, but the conduct could be bigger than that. It
the
could
jury
be-
said otherwise,
Well,
I
no,
think.
I don't know that the jury said otherwise. Your argument is that. I just want to understand your argument.
Yes, it's the basis of the jury note
All right.
there. There are two
Can
other.
I'm sorry.
I'm
not
sorry
sure
if I
got
misunderstood.
No, the question was, so I think she said 9,000 of the 13 was attributable. We know that 9,000 was attributable to the rat poison, which is what the jury did convict her. So do you agree with that?
That's what's in the estimate. It appears from that, to decipher the estimate, that's as best I could. So yes.
Then your argument would be that estimate is not specific enough, or the same other arguments you have about it, but you don't disagree that in theory you could split
Yes.
the two up.
Yeah. I will say I'm kind of shocked the pesticides haven't been destroyed, in part because the restitution statute allows restitution for losses, not future losses. So the government, as I understand it, has not obtained any loss yet. And that's the problem with relying on estimates. I will also say,
Ever been in a criminal procedure where the government still has not disposed of stuff, and where then the district court or any court has said the government then cannot get restitution?
we do not do a lot of restitution practice in our district.
I was on the district court, and many times the government would come in. They haven't quite disposed of everything, but they have a reasonable estimate. That's why we have that case, and that's why I cited it to you. It's the reasonable estimate, based upon the facts, the amount of the loss with reasonable certainty. That's why you have that case, Doe.
As far as I understand it, the government yet hasn't obtained any loss.
Okay.
So my third point here is under the EPA regulations,
That okay was not great for her, but he's never coming around. What he doesn't want here is because if she wins on this point, if they establish a principle that they have to have actually incurred the costs, then that might throw a little bit of a wrench into all those estimates that they're using elsewhere. So that's interesting. I think that's a very interesting aspect there.
if you show up to the border, even without a notice of arrival, the EPA still has the obligation to hold pesticides that you did not declare in advance, you did not follow the system. It still has the obligation to hold those and allow you to export them. That's 19 CFR 12.113B that's cited in our briefing. I do want to be clear here. Under its own regulations, the EPA and CBP could have chosen to let Ms. Perez turn around, or another member of her family who lives in Mexico, pick up the bag of groceries, drive the 15 minutes to the feed store, and return them with the receipt she still had where they're legal to use, legal to have, and legal to sell. And so in this case, I've yet to hear any reason where these pesticides are not held as being the cost of prosecuting her. The government, of course, is entitled to prosecute her and hold them, but Salcedo Lopez says her conduct did not cause the loss. It was the government's choice.
Great. Thank you. Thank you, both counsel, for the very helpful argument. The case has been submitted. Next case in our calendar is Junior Sports Magazines versus Bonta.
All right, so now this is going to be the part that everyone gets annoyed at because they're going to say, wait a minute, who won? And nobody won yet. This was just heard. They're going to think about it. They're going to go back and they're going to argue. And I think that the argument is going to be, I don't think anybody on this panel agreed with her argument about, the first argument there. I I don't think anybody went with that. The argument about the jury instructions. I think on the arguments about overall, the arguments about what do you call it? The restitution amount. I think that what you'll see is I suspect that they're going to say you've only got to pay $9,000. $9,000 is for the stuff that they actually found was illegal, but you don't have to pay the $3,000 or the $4,000 for the other stuff. So that's what we're looking at there. Traveling science men, yes, and I also have to respond to you on with that message you sent me. I'll shoot you a message there just to sort of let you know what the situation is there. But that would be fantastic if you got the case number handy. How did I know that I won at the Supreme Court of Canada? You celebrated that night, correct? I got a bench verdict. So the bench verdict was just, they often the Supreme Court reserves, but rarely they will issue a verdict from the bench, or sometimes they'll issue a verdict from the bench. So in my case, they issued a verdict from the bench, and they said, we are ruling in your favor. So I did celebrate right then. Was there trial of the century prep earlier, or is that a different day? That had to get rescheduled because Rob has some life stuff that he's got to deal with. So, yeah. All right. Nicholas Staro's Trial Watch. Barn is almost guaranteed from you not being caught doing stabby things, stabby lighty things, though. That is true. Are appellate courts just a 13th juror? Not really. Appellate courts have got to sort of review things. There's different standards for all of that. And I see here we've got, all right. So now I'm going to do a swoop, and then we'll move on to junior sports magazines versus Rob Bonta. And we'll talk about why it's Rob Bonta. All right, swoop. It's the Zora going, screw this. I'm out of here, swoop. All right. So Rob Bonta is I believe he's the Attorney General. So he's being sued, but it's really they're proceeding against the government. They want to throw out an action from the government. So this is the gun ad ban case. So California put in a law to say you cannot advertise guns to minors. So that's what they're fighting about here. So let's have a look. And yes, the pup swoop is the best swoop. I have to do more pup recording. Booping. All right, so because you saw, this is literally, they're just like, okay, next case. Everyone's unpacking their bags. Everyone's getting clear of the table. They're, and appeals courts will be like this. They'll have multiple appeals to be heard in the day.
Good morning, Your Honors.
You're
May
done.
it please the
Next
court.
people.
Anna Barver for Appellants Junior Sports Magazines. I'd like to try and reserve 3 minutes for rebuttal.
So junior sports magazines, they are basically they are gun magazines that do or they're magazines that cover junior firearm sports. So yeah, I see gun ads to minors. It actually goes beyond that. So
Through the adoption and enforcement of Assembly Bill A 2571, the state of California has chosen to ban all firearm industry members and only firearm industry members from engaging in speech that promotes firearm-related products. This includes firearms, ammunition, and all sorts of accessories that can be used in conjunction with the carry or use of a firearm. If that speech constitutes advertising or marketing, that might reasonably appear to be attractive to minors. In doing so, California has enacted a very broad ban on pro-Second Amendment speech about items that are entirely lawful to use and possess in California, even by minors. In service of California's purported interest in ferreting out the unlawful sale of firearms to minors,
She's not whispering. She's just very breathy. Um, so, but I don't mind her voice overall. I think she's doing all right in terms of expressing herself.
this speech ban is hopelessly over-inclusive while also being under-inclusive, vague, and thus chilling. This fact is fatal to the state's case, no matter what level of scrutiny applies. That is because AB 2571 cannot survive even the slightly more forgiving test for commercial speech under Central Hudson, because AB 2571 is not in any way appropriately tailored to this public legitimate interest that California has put forth.
She is nervous as hell. She is stressed as heck, and that is, I'm wondering if this is like, is this her first time in the appeals court? It might be. It's possible. I don't know. But she's clearly nervous as heck, and this is a point. Don't read. So I make a point when I'm going in front of an appeals court. I'll have to see if I can find my Supreme Court notes, because my Supreme Court appeals brief, like my appeals ready to go plan, includes nothing that I could read from. There was absolutely nothing that I could just read as text. And the reason why is because if you have it where you can read it, then you will read it. And once you read it, you're just, you're doomed. So that's not a place you want to be. You want to be in a place where you can't just read it. You've got to, actually parse it out. Like, you can have notes where you've got points you want to say and points you want to hit, but you can't just you can't just be reading, because if you're just reading, you're gonna get hammered. So that it's an important trial skill there. Let's keep going.
That is by design, because, let's be real, AB 2571 was never really about preventing the unlawful sale of firearms to minors. The legislative history is chock full of references to the primary impetus for the law. That is animus for gun culture and firearm industry members specifically, and a bare desire to thwart the passing down of pro-gun messages to our future generation of shooters.
And that's really what a lot of this is about, right? This is not so much that they think that this is not so much that they think that realistically, they don't think like some 12-year-old is watching a gun ad on TV and is like, I'm going to go buy a shotgun, because they can't. They walk into the store and they say, hey, I want to buy a shotgun. And the store owner's like, you're 12 though. And they go, yep. And the store owner says, great, get the F out. There's just no universe in which they can do that. So really, this is that they don't like guns, because this is California, right? So that's what this is about. What is it? Future generation of shooters. I mean, it's accurate, but yeah.
We can look at the excerpts of record, starting on page 1028.
I think we ought not necessarily get into the that kind of thing if you want to win this case. What I want to get into is, why isn't this commercial speech?
Oh, what is it? We're not going to get into that if you want to win this case. I'm like, dude, I'm not liking this guy on the left a whole lot. So, yeah. And somebody's saying, wasn't there a kid at the Gundies? Yeah, she won because her content is actually pretty awesome. So there was definitely a kid at the Gundies, and she was kicking butt there. Yeah, and this is what Andrea Burkhart does for a living. So, yep.
Commercial speech is certainly speech that is an advertisement, speech that refers to a particular product. Speaker has an economic motivation in speaking it. It's right out of Hunt versus City of Los Angeles. Seems to me this is an easy case for commercial speech.
Like, he just slapped her down, so now she's got to recover, right? Now she's got to recover from that. So he's saying, why isn't this commercial speech? And the reason why he wants to classify this as commercial speech is that commercial speech is entitled to less protection than some of the other kinds of speech. It's a less important thing, right? Uncivil is saying, I'm hungry. What should I get? I just got sushi. That's what I ate earlier, and sushi was fantastic. So that would be my recommendation. So this is a hard thing to recover from. That's hard slap down. So let's see how she does.
There, obviously, AB 2571 does restrict commercial speech, but appellant's theory of this case is also that it necessarily ties in pure speech, because as my clients, especially junior sports magazines and our Second Amendment organizations like CRPA and SAF, the events that they participate in that involve pure speech, that pure speech is basically paid for by this commercial speech. If junior sports magazines cannot sell advertising about firearm-related products, and we're not just talking about firearms here, we're talking about sights and holsters, portable gun cases, gun safes, for instance, all of those things, then it can't really exist, right? Magazines rely on traditional advertising, including that which is banned by AB 2571, in order to publish pure speech. So as the record shows, Junior Sports Magazine could have done two things, right?
Now, I am really curious as to what they do with this argument, because basically what she's saying is, listen, they're going to suppress everything else we want to say about the Second Amendment and various other things by attacking our ability to fund it. And I actually, I see the point. I just don't know that they're going to, that they're going to go for it. Now, I actually think that this is a place where I'd want some evidence to say, listen, this was the point of this. Their goal on this was to shut down that, speech. But he's already said he doesn't want to hear that. So, yeah. What's it? I don't recommend this at all. Go to a vegan restaurant and order a Reuben. Proceed to feed off the confusion and hate. You might actually get a vegan Reuben. So you might not want that. All right.
It could have decided to stop taking those ads altogether, right? And then, because this is a national, this is a magazine with nationwide distribution, if it stopped doing those ads altogether, that's a substantial amount of its revenue, risks shutting down the magazine altogether, or as it chose to do, keep the advertising.
So you're saying mixed motive?
Correct. It necessarily attacks both.
I understand your argument.
He said, get to the
reason
point.
I ask you that to begin with, supposing that I suggest that in my review of this, and this is a de novo review now as to whether it's commercial speech or not, I think it's commercial speech.
Okay.
So then at that point, it seems to me that you need to address the other issues that would be outlined in Central Hudson. Because to go on about your mixed motive, it's not going to help you much if I'm on a commercial speech path.
So he's basically saying, I've already decided that this is commercial speech. So you need to tell me how you can win with that decision, and like with that, convince me that I should win. Yeah, and I see this. It's not a good argument. All commercial speech generates money for possible good speech. The cigarette companies probably had some community corporate involvement that could be speech. I think in this case there is a record from their comments in passing the law that their goal was to shut down gun ownership generally, right? And that they don't like gun owners, that they don't like that. So, yeah.
So what about, is it lawful? Is it truthful?
Yes, Your Honor. This
Because
speech,
then I have to ask those two questions to get to the final three.
that's correct.
And those are legal conclusions, right?
That's correct.
Lawful and truthful.
That's correct, Your Honor.
And it seems to me.
He loves the cross
that
exam
there is
style.
some lawful sale, or there would be some lawful advertising. And if there's some lawful advertising, then it would be lawful speech.
That's correct, Your Honor.
And it seems to me there'd be some truthful advertising, so therefore we would get to truthful speech. So then we would go to the last three prongs of the Central Hudson test, correct?
Yes, Your Honor.
And then we get to a substantial government interest.
Correct?
Is it a legal conclusion that it is a substantial government interest? Or is it a factual conclusion?
It's a good question. I think,
The reason I ask it is, we're on preliminary injunction here,
correct.
abuse of discretion analysis. If this is not legal, then how much is it an abuse what the district court did?
I think the response here is twofold. First,
He really likes
I think this
shutting
is
stuff
not
down,
a
I
strictly
think.
legal or factual question, and since it's a mixed legal and factual question, it
Why,
is,
what case says that?
oh, I'm not sure, Your Honor.
I
I'm
don't think
sorry.
there is one.
Regardless.
So that was him calling BS again.
Even if appellants concede that this is a substantial government interest, plaintiffs obviously argue, and we think this is this is all pretext, and we can talk more about that later. But even if we concede and the court accepts this interest in preventing the unlawful sale of firearms to minors and preventing gun violence, we would obviously concede that under any test, that's a substantial government interest. It comes down to then whether or not California has shown that the harms it's reciting are real and that the ban directly and materially advances it and is no broader than necessary.
So we're down to, does it directly advance the interest, right? Is
Correct.
that what you're arguing?
It's one of the things.
Is that a legal conclusion,
I think it is.
or is that a factual determination?
So he's asking
if
that
it's
because it
factual,
determines the
Have an
standard
abuse of
review.
discretion standard.
That's right. But I don't.
And we have a judge who had the original decision to make, who made that decision, and how much am I bound by what the judge did? If it's an abuse of discretion, then I've got to say, he got the law wrong on that, or it was so outlandish, his idea of the facts, it wouldn't hold up. Whereas if it's a legal conclusion, I can substitute my opinion for it. That's why I wanted your good help.
Thank you. I think
like, give me
no
the
matter
answer
which way
I'm
you
asking
hold
for
abuse
here,
of
please.
discretion or this is a factual question or if it's a legal question, the result is the same, right? Because, it would be an abuse of discretion for the court to get the law wrong,
Oh,
right?
don't say
And I
Right,
think,
but I don't know that they got the law wrong.
I would think that, respectfully, I think they did get the law wrong.
What case would suggest that the way they applied that law is wrong?
So the court, so the state is pushing a theory that they are allowed to, that they have a that the state is allowed to dampen demand for these products, and it bases that theory on a number of cases that the district court adopts in its decision. Cases like Edge Broadcasting, Coyote Publishing, Act Media, and 44 Liquor Mart. These are all cases, of course, that deal with tobacco, brothels, gambling, alcohol, things that minors are not allowed to use or possess at all, as opposed to a case like this one, which is more like Carey v. Population Services, where we're talking about an unconstitutional ban.
Just so people are aware, she's going to raise issues of abortion and birth control issues. So if that's an issue, then you may want to step out. That's just the discussion. Yeah, she's swinging it back around. I think that's she was having some trouble and she's swinging it back around.
On contraceptive advertising that went to both minors and adults. And so this case, AB 2571, suppresses similarly information about the availability and price of constitutionally protected products that minors in California may possess legally under supervision or the permission of a responsible adult. So the court, in relying on cases about tobacco and brothels for speech to minors, was an abuse of discretion. It should have been looking at Carey, which, when we're talking about contraceptive advertising, which is about a constitutionally protected product that's lawful for minors to use.
I think at the point where you start talking about, where you have to keep saying brothel, that is not a place I want to be in in an argument. So, I mean, this is better than when the judge there had her on the ropes and was dragging her into a particular line of, basically dragging her into losing, which is what he's trying to do. But now she's still doing better. But brothels is not really where you want to be on all that. So
if California changed its laws and said minors, can't use guns for hunting, shooting competition, etc., as it currently allows, would they be allowed to pass a law like this?
They may be able to get through with that under cases like Edge Broadcasting, but then you obviously run into a clear Second Amendment violation, and then we talk about the Second Amendment violation, and then if they're violating the second, then are they violating the first also by doing so?
So basically what she did there is a slightly better reframe of the hypothetical, in that she said, yes, probably, but that would also violate other rights. So in that case, they would still have problems, but she stuck to her legal principles, right? So she stuck to her legal principles, which I think was a good place to be.
One, is it more extensive than necessary? And again, my question is that a legal conclusion or is that a factual conclusion? Because my colleagues and I can only stick our nose in if it's legal, unless they have abused their discretion, the district.
He keeps asking her, say it was a legal conclusion. Say it was a legal conclusion. Like, he's like, I can't tell you to say it, but hint, freaking hint, this is what I'm looking for you to say. Hint, 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 hint. And she's not getting the hint.
Court in some way.
Our position is that,
and I'm not really telling you where I'm thinking. I just want your view on this.
our view is that these are legal questions, right? Applying these legal tests.
You had a case to tell me.
I'm sorry, Mr.
I wish you had a case that said the same thing you're saying.
I think what I'm trying to get at is the Supreme Court cases dealing with these types of speech tell you where to go with how broad these restrictions can be on speech when you're dealing with constitutionally protected products and speech to minors and adults. Because remember, AB 2571 is about what might be attractive to children, not not speech that they've actually read or speech that is directed to them. It includes speech to an adult like myself who might be willing to look into buying a firearm-related product for my minor daughter to use under my watchful eye in accordance with California's laws. And she's never seen the speech, but because it's maybe a pink handgun with a Hello Kitty attached to it, that speech to me as an adult is illegal under AB 2571. And I think, and I think because just the very, looking at the law on its face, we
It's
can see.
absolutely
that
nerve-wracking.
It targets speech that's directed not just at children, but as adults who might be purchasing firearms for themselves, purchasing them for their minor children, or even to speech for children about firearms they may use legally or purchase when they become adults. I think the case law is very clear that this is too broad. In all applications, this law is too broad to survive the Central Hudson test. I also want to talk a little bit about plaintiff's equal protection claim, right? We're looking at a case of a law that was obviously driven by animus for the firearm industry. With this, while they have a public-facing interest, the state.
She's actually getting less nervous as we go, which is good. But we'll see. I mean, her getting less nervous is a good thing, but she's still having a fair bit of trouble. So.
Claims in preventing the unlawful possession and purchase of firearms by minors. We can see in the legislative history the real impetus was this animus. There's lots of talk about in the legislative documents about the problem of indoctrinating our future generations into the gun culture. And then you have exemptions
If we're on equal protection, who's the protected class?
This is not a case about a protected class, Your Honor. This is about one of two things. This is an equal protection claim about discrimination in the
But what
use
class is not protected equally?
This is about
Why it's
discrimination.
an equal protection class?
An equal protection claim based on the exercise of a fundamental right or based on animus driven toward an identifiable group. In this case, obviously, is the firearm industry members.
So guy on the left is lost, right? Guy on the left, I don't think is ever going to swing around here. He really doesn't like this argument. And yeah, I don't think that she, at this point, getting stuck on this guy is causing her a problem. So, yeah.
And because there's
To me, that if we're going to go back to equal protection, and I'm not trying to avoid it, I'm just trying to say, if we're really going to say it's a commercial transaction, we don't really need to talk about an equal protection argument, do we?
if Your Honor would.
That would elevate it to strict scrutiny. That's the reason you're coming back to that argument.
That's respectfully, that would, what my position on it being about animus based on disdain for the firearms industry, that's rational basis. And because it's
I
animus,
understand.
there's no legit.
He's not taking her seriously at all, right? He's just, and I think the guy on the right is actually getting a little annoyed at this point. Like, he looks like he's a little annoyed, going like, hey, can you just let her get her points out? Because we know you don't like her. So, like, but still let her finish.
Legitimate purpose.
But if we're going on a preliminary injunction, we've talked about, it seems to me you're saying you're going to win on this, so we would have met the first part of the preliminary injunction winner factors. In that, seems like you got a good case. So then, irreparable harm. What irreparable harm is there?
So they're talking
Under
about
an equal protection
injunction,
analysis,
which
Your Honor?
is,
No,
On any
on
of them.
I'm
Obviously.
back to commercial speech.
Okay, sorry. Obviously, the direct and most irreparable harm, of course, is the chilling of speech. The record shows through declarations that my clients have stopped engaging in all manner of
There
speech.
is no constitutional issue, then no harm, but if there is, then it's even under commercial speech, you would have your harm, right?
That's correct, Your Honor.
How about a balance of equities?
The balance of equities, I think, obviously, because we're talking, if it's a constitutional violation of fundamental rights, then the balance of equities is going to naturally fall on the side of my clients.
What if it's freedom, what?
Oh, now, I'm just looking here. I see, I'll address this. Wonder if it was a male, would he have acted in the same way? I can't speak to this guy specifically, but I can say I've gotten rough rides in the court. So one of these days, maybe I'll try to watch my Supreme Court hearing and we can go through that and I can sort of comment on like some of the, or at least one of the justices really did not like my arguments, which is why I got a split. I think it's just this guy. I think I suspect this is just his way of responding to things. Some judges are, will throw their weight around a little bit more. So, yeah, that's kind of my thought on that. But we'll see.
What if it's just a mere commercial speech?
If it's mere commercial, I think it's still true because even if it's commercial speech, we're still talking about protected First Amendment rights, right? If you're violating the First Amendment based on quote unquote just commercial speech, it's still violating the First Amendment.
Well, don't we, when a balance of equities, we say we act to preserve the status quo and minimize harm? Isn't that what we do?
Yes, and what is interesting about that, Your Honor, is
But
that
the harm
we
she's
were trying
talking
to,
about,
to keep the status quo.
what she needs to point out is that them not being able to speak is a substantial harm. There's a reason why they don't usually give injunctions in defamation cases, for instance, is which is that like prior restraint. So I think she needs to come around to a better argument here.
The legislature chose to adopt this as an urgency measure that went into effect immediately as Governor Newsom signed it. Like, if it had gone through the normal process where it would have taken until January 1st or perhaps July 1st, we would have had the time and the status quo never would have changed. Really, this status quo that we sit in right now only exists because it went as an urgency measure. It didn't need to. There was really no reason for it to take that tact, and we could have been preserving a status quo where the law didn't exist. And I would also add, sorry.
Go ahead.
I would also add that preserving a status quo that silences my clients would not be just.
And as to the public interest?
As to the public interest, again, if we're speaking about a violation of the First Amendment, even if we're talking about commercial speech, I think the public interest is on the side very clearly of protecting constitutional fundamental rights and that the public interest would fall on our side. And I would also say that if the court rules with appellants and grants this MPI, you're not going to see some massive harm to the state, because enforcing unconstitutional laws doesn't harm the state naturally, but also because we're talking about an interest that the state has in preventing gun violence that they haven't really shown is directly linked to this advertising that they're trying to ban. Unless the court has other questions, I'd like to reserve the remainder of my time.
Great, thank you.
Thank you.
So, yeah, she's like, let's hold off. And I see, get this to 500 likes. So if you haven't hit the like button yet, please do. I think we've got one super chat here I should cover while we're doing a switch here. Will they also try to ban A Christmas Story because it glorifies the Red Rider? I mean, this is part of their argument is, doesn't this ban way too much speech, way too much discussion, way too much all of this? So, yeah. I love seeing her find her groove after being so nervous at the beginning. I can tell you, when I went to the Supreme Court, I was nervous AF at the beginning. And right at the beginning, I launch in and I'm sort of doing my thing. And I'm going, I really hope you got some questions because I've only laid out 5 minutes for like my intro. and I hope I don't get through 5 minutes, because if I do, then I'm off the rails and into into the woods. So thankfully they started asking me questions, and I was nervous as hell responding to them, because they're the scariest Santa Clauses on the planet. When I say the scariest Santa Clauses, I can tell you, like, our Supreme Court in Canada dresses up in outfits that are red and white fur, so they look like Santa. I mean, they're wonderful, but they look like Santa. And so, yeah, it's, yeah. And I see, spoiler, Runkle wears his old man glasses at the SEC. I don't have those glasses anymore, but yeah, I saw that. It was obvious how nervous you were. I hope it wasn't that nervous, but it was I was pretty nervous. So maybe sometime I'll do a stream just talking about like what the experience is like being at the Supreme Court, and discussing that. All right, so let's roll. Oh, and we got a question here that we should maybe look at. Can someone give me the TLDR of what's going on? So California has put in a law that bans advertising anything that kids might find attractive that relates to firearms, which includes guns and slings and scopes and sights and all of that stuff. So, yeah. All right. And now we're just hearing from California, basically.
Good morning. Gabrielle Boutin on behalf of Attorney General Rob Bonta.
No, wait, I think I was on my own.
This is an appeal from an order denying a motion for preliminary injunction. Such orders are only subject to reversal for abuse of discretion. Here, there was no abuse of discretion in the district court's ruling. Section 22949.80 is a narrow measure that restricts only advertisements for defined firearm products that are directed at children. The statute regulates only commercial speech, and it does not regulate non-commercial political speech related to firearms. As a result, under the applicable Supreme Court and Ninth Circuit precedents, the statute is subject to central Hudson scrutiny, which it satisfies. The district court properly applied this legal standard. We therefore ask this court to affirm the district court's order denying the preliminary injunction. With that, I would be happy to respond to any questions that the panel may have.
I think this was terrible. I'm going to say why I think this was terrible. She basically just said, hi, here is who I am, and we ask you to win, to have us win. I think this is where you want to actually address more strong points. She has some arguments, but I think it was a little weak there. I would have really tried to hammer, more of the point. I think she didn't give herself enough runway there. I'll just look at a couple of super chats that have come in here. Jay Baffo, Ian, I think this is very valuable. The public has no clue about the difference between trials and appeals. The Depp Heard appeal made that clear. That's pretty much why I decided to do this. I was originally watching this so that I could do a video on this and just talk about what happened. And then I realized, I was like, I don't think I've ever actually seen like a live stream commentary. Uncivil's probably done one, but I'll have to check. But just talking about like appellate stuff. Appellate work is very different from trials. Like, none of them have evidence, and you can see that at points where they're trying to say like, well, if we'd done better, we could have won. They're like, yeah, if you were a unicorn, you'd have sparkle farts. Like, that's not where we're at here. So you don't get to retry things. You don't get to any of that. And I think that's really important, just to be aware of. I see scary Santas. They're scary Santas. I mean that with, respect, but the costumes are a little weird. I would love to see you, Andrea, and Kurt address appeals. That's an idea for a great show. I should try to get everyone together. So let's, I'll try to get that set up. Kurt, if you're still here, let me know if you're in on that. So, all right.
How does this law directly advance the state's goal here? And maybe more specifically, is there any evidence that a minor has unlawfully purchased a gun in California?
I think
So has this ever happened is basically what he's saying. Have we ever actually seen a kid, like has an 8-year-old ever walked into a gun store, put $500 on the counter and been like, Glock me? She's actually got a pretty good argument on this. So let's see that.
this actually might relate a little bit to Judge Smith's questions, and because it has to do with what type of review are we doing?
Before you get to that, I mean, is there anything in the record that shows in the state of California a minor has unlawfully purchased a firearm?
There is not evidence in the record of that specific incident. However, the case law, such as in Edge Broadcasting by the Supreme Court, discuss this issue of, do there have to be specific incidences in the past record of the incident happening? So in that case, it had to do with
I just want to say this is how, like, she's dealing with that well, in the sense that he says, has this ever happened? And she says, no. However, and she just keeps rolling so that she can get to her point. Because this is like, you can't just say like, no, if you have more to follow up with, because otherwise you've missed that opportunity and you've sort of bombed your point. I see somebody saying she's misdirecting. She's not misdirecting. She's trying to make a point. Like, she's saying, hey, the prior case law says we don't need that. Like, you're asking me for this thing, but we don't need the thing. We don't need that in evidence to win here. So it's really important that she gets that out. And if she's not able to turn that around and to get that point out in response to this question, it totally tanks her. So she's doing a good job here.
restricting radio ads for buying lottery tickets. And the court upheld that law. And the court talked about how certainly there was no discussion of evidence in the record of that having happened before, someone being stimulated to buy a lottery ad, buy a radio advertisement. And the court also talked about how it's permissible under it is permissible under Central Hudson scrutiny for the legislature to take action with the thought that it will benefit the public at large, or there will be a general effect, and it doesn't have to, in every single circumstance, cause the desired result.
So what is the state's position on how this is? So it's not so much about minors unlawfully buying guns because of advertisements. So is it on theory that lawful, truthful advertisements about guns that may be reasonably attractive to minors, stokes demand for guns among minors, or increases gun violence among minors?
The idea is that these ads, and I want to get my language correctly because it sounds like you were trying to get some specificity, but
I want to get my language correct. So that's a verbal stall, right? She's doing a verbal stall there to buy some time. But I will tell you, that's not the right verbal stall. It's okay to say, I just am going to think about that for a second. That's fine. People will judge you. I mean, you can't think about things for too long, but you have to, yeah. So, what is it? All right. What is it? Yeah, I think that verbal stall that she was doing actually makes her sound like she's going to come up with something that's a bit of BS. It sounds like she's saying, I need to phrase this in a way that it doesn't sound like bullshit, but she knows that it's going to sound like bullshit.
It's that the ads lead to minors' illegal acquisition and illegal use of firearms. And the case law supports this idea of dampening that demand by restricting advertisements. Again, there's Edge Broadcasting. There's the Lorillard case, which has to do with restrictions on advertising.
Could you, minors misuse, unfortunately, lots of things, right, including cars. Could California pass a law that
Oh,
banned advertising of vehicles aimed at minors.
I like this guy on the right because this guy on the right, he's quiet. He's sitting there. He's sitting there. He's sitting there, and then he just quietly, he just quietly knocks your house down, like just quietly rolls a hand grenade directly into your living room and goes like, "Hey, did you think about this?" So, yeah, that's this guy is the guy to watch out for.
That be under the idea that some minors misuse cars, and therefore we're just going to ban all advertising of vehicles that might be geared towards minors. Could they do that?
So my understanding of your question is the idea would be that the consequences, the harm that is trying to be alleviated is car crash fatalities and injuries caused by minors in particular. I assume that
No,
that would
just
be kind of
just
justification.
assume. I think we all that minors misuse cars sometimes. I have children, and I think that's true.
If we're talking about the direct advancement prong of Central Hudson, I think it may pass that. I think
But what about the overbreadth?
that's where I think that could possibly be an issue, and I think why.
Why would that not be similarly true here? Because, I mean, we look in, legislature actually said that they had a compelling interest in ensuring the minors do not possess these dangerous weapons. The legislature didn't even seem to be targeted necessarily, or at least they were.
Yeah, she gave up more than she wanted to there, I think. She's going to have trouble with this line of questioning, I suspect.
Inconsistent about whether they were targeting illegal possession or, you agree that you can have lawful possession as a minor.
Yes.
And
Yes.
so they seem to be just targeting lawful possession, at least in part. At least there's some language to that, and I can understand where you want to distance it. But like even assuming the legislature had only been wanting to target unlawful possession, but has something that says you can't advertise it at all, and it bleeds over into lawful possession. Why is that not a problem? It seems like it would be with cars or soft drinks or any number of
I think there are
violent video games.
First, to go to the initial part of your question, even if there is language about possession generally, their concerns were about violence caused when the acquisition or the possession was illegal. So school shooters, for example.
Well, they have two concerns. I'm going to hold you to their language a little bit. There's an and here, and they have a compelling interest in ensuring that they don't possess them. They didn't say illegal, they said don't possess, and then they also in protecting citizens, especially minors, from gun violence. So, but those were independent like concerns, it seems like. You're kind of merging the two together, and you're saying that it's a possession, that it's only possession that results in gun violence, but that's not what they said.
Well, Your Honor, I think the statute speaks to that issue by.
She is having trouble. And I'm going to say this is something that happens to appellate lawyers all the time. And what this is a symptom of, I think, is that you rehearse the parts of your argument that you think are good. And then you're like, I'm going to go in and talk about all of these things that are good about my argument. But that's not what the justices want to hear or the judges want to hear. They want to hear the parts that they think are bad. And so, like going to the Supreme Court, the stuff I was sure I was strongest on, I rehearsed a little bit. The stuff that I thought I was weakest on, I went to town reading. And I just, I actually, one of my best friends for reading over stuff is, there's a guy I know who will always, when I give him like a factum or a memo that I've written, he will come back and he will tell me all the parts he says sucks. And that is really invaluable. Right now, she's in like this stammering. She's trying to figure this out on the fly, I think. And that's not a good place to be. This could have been avoided with some better prep, I feel.
By the fact that there is an exception in the statute for activities in which youth are using firearms legally, which has to do with programs for education, hunting, shooting. So certainly that provision would be at odds
If you just,
for trying
if you
to.
just advertise a 22 Henry lever action rifle, which I think would be legal in California for, it looks like.
This should be her danger moment of like, if he's just advertising and he names a specific make and model of firearm, she's like, all right, this guy shoots. That's causing some trouble here. Jenny, I'm sorry, we're doing appellate commentary. I'm not sure what the problem is. I'm not sure how to help here, but yeah, this is how appeals look.
Like an old Western gun kind of, for with a kid, because it's a 22 caliber. I think that would be illegal under this, right? You would agree, like if it doesn't have anything to do with like trying to promote safety or trying to promote some kind of group or something, it would be illegal. Has a picture of a young child hunting rabbits with a 22 rifle or something like that, which would not be illegal necessarily.
That's right, Your Honor.
But it would, the hunting would not be illegal, but the advertisement would be, correct?
Well, I think you would have to look at the factors, and you have to look at the very specific ad. The factors get pretty specific in terms of a lot of other issues other than just the main subject of the ad.
So is your argument, just to be clear, is your argument that this only reaches advertisements that are asking, they're like intentionally encouraging children to engage in illicit, illegal violence? I don't think that's right?
No, no.
So, I mean, so are you even disagreeing that there, is your position that you can't, that this, do you disagree that this would cover advertising firearms to minors where you're just advertising the firearm? I mean, there's instances where this would cover, you're saying we have to look at the factors, et cetera, but you agree that like it would actually cover advertising something to a minor where the minor, if the minor respond to that advertisement, the minor would be engaging in a lawful activity, say rabbit hunting with.
Again, I think it depends on the specific ad that you're looking at, but I think it is possible that that may be the case in certain instances. But my response to that would be that a perfect fit is not required. Yes, you look to over-inclusiveness and under-inclusiveness, but this is not strict scrutiny, and it only has to be a reasonable fit, which means there could be some over-inclusiveness. So, for example, in Edge Broadcasting, part of the claim was that.
So she's just basically conceded that it may be over covering. That's, I mean, she's gotten backed into a corner here, which is, this is a bad place for her to be. I think she's causing some trouble here. Guy on the left, I think, was never really in play. Guy in the center is really the, I think he's the decision maker on this one.
It was over-inclusive because there were people who would hear the radio broadcasts that were in states in which lotteries were legal, and that was not the intent of the statute. But the court still said the court still found there to be a reasonable fit. In the tobacco advertising cases, again, there were regulations that were upheld that were also targeted at adults, so legal behavior, whether it be giving out samples, whether it be keeping the products behind the counter. But so there is over-inclusiveness that is allowed in these cases under Central Hudson review. So there will be certain cases that may be borderline in terms of is it a fit for the interest, but that doesn't mean that the law should not be upheld.
So if there was an advertisement that said a hunting rifle, it has less recoil, so it's young minor hunters, it would be easier for them to use to go hunting. If there was an advertisement like that in Junior Sports Magazine, Sportsman Magazine, would that be unlawful under this law?
Again, I think you'd have to look at the totality of the circumstances. I think it's possible that could be one consideration that the court undertook. But so if you said that. So I think if there were aspects of the ad that looked like they were supposed to appeal to a child.
So now she's now she's flustered. And she's saying if there's aspects that look like they were supposed to appeal to a child, this is getting into very fuzzy aspects. And this is what we talk about. So when you're talking about, free speech issues, one of the issues that comes up is what they call a chilling effect. So let's say you've got content that is definitely illegal, right? Planning to kill the president. The discussions that you have around planning to kill the president, definitely illegal, right? But let's say you phrase your statute in a way that's so broad that it creates a big fuzzy aspect, like a big fuzzy area. So let's say people say, oh, well, you can't also say anything that might induce another person to want to do that. Oh yeah, this is an example, but so at that point you get into really fuzzy problems where you end up where that discussion could cause you issues in the sense of if you say, like, I don't like the president and I think he's a bad person, does that get captured? And if so, then you've got this huge chilling effect where legitimate speech, people don't want to say the things that they're legitimately entitled to say because they might get shut down for it. So that's sort of the concern there. I'm going to move on because people are saying, hey, you're going to get shut down. So let's keep going. We're past 2 hours, but we can roll this. All right, let's keep going.
Audience that the child was supposed to read
Yeah,
that.
yeah, the gun,
And
it says
yes,
that these guns
then
are
yes,
better
I
for
think
minors.
it would fall under that. But I think there could also be certain aspects of the ad in terms of the context, the design, that the text itself that made it more clear that that made it not attractive to a child. So I mean, I think I think there's certain circumstances where there may be something
Let's say
directed.
it says at the bottom of it, this is an advertisement for children because they're hunting with their parents, and following the laws, because their lawyers got involved, and following the laws, because we think this gun will be really good for, having less recoil and help you to have better aim. So that, and just to push back on, the problem is it almost sounds like, if you're a fire industry lawyer, you keep saying, well, you have to look at all the content. In order to engage in this speech, you're kind of, the way you're presenting it, you're out there and you have no idea what the result's going to be. I'm not sure it's actually as vague as you say. I think it may be actually more clear that it does ban it, but even assuming it.
Yeah, he's actually saying you're really presenting this in a terrible way because it actually sounds like you're trying, like this law is a lot more vague and, and fuzzy than it is. But I think the reason why she's doing that is because she doesn't want to admit that it would be covered. Julia 543, shoot me a link. If anybody's got me or got a link to that massive document dump, I will dig through it and see what we can see. All right, carrying on.
It's as vague as you say. Isn't that a problem too?
No, I don't think, and I didn't mean to give that impression. It's difficult to discuss hypotheticals when there are several factors and it is a totality of the circumstances test. But I think when we talk about vagueness, excuse me. So with respect to vagueness, first of all, what it sounds like you're discussing is a fair notice issue with the factors. And my first response to that would be that's not an argument that the plaintiffs made. They discussed arbitrary
Well, I'm not actually
enforcement.
super interested in vagueness. I'm just saying that you are really emphasizing the vagueness of the statute in order to get away from our
Well,
hypotheticals, and that seems to work against you.
I certainly don't mean to do that.
So what he just said is, you seem to be a giant weasel. And maybe you want to be a slightly smaller weasel, or maybe not even a rodent or, a mustelid at all. Like, that would be, get away from the Mustelidae and the Rodentiae families, and maybe not do that. So yeah. Yeah, I see people noting Her argument, does seem dishonest. Yeah. But can't you see guns are icky and gross? Oh my God. That does kind of feel like where she's coming here. What is it? Could I cover Britney Spears? I think that's mostly resolved, but if it fires up again, I could look at it. Yeah. All right.
Standard is whether it is attractive to a child, and it certainly is the case that in certain circumstances, such as if there's a statement in there that is meant to speak directly to a child, yes, that probably, perhaps certainly would fall under the statute.
You admit, so to get away from my hypothetical, if you were advertising a firearm and you're clearly trying to advertise it to a child audience for a clearly lawful purpose, let's just say those two things, then you acknowledge that this would cover some of those instances.
It would, and part of that is because the statute does also cover advertisements that are designed or intended to be attractive to children.
So she admitted the bad thing, which is going to be a problem for her. Guy on the left is unhappy, I think, because I don't think he likes these admissions.
Obviously, a lot of these situations would be covered under those provisions. And again, I think because you don't have to have a perfect fit, because it's not strict scrutiny that's involved, it's okay that there are going to be some circumstances in which there could be, one could argue, it's more about legal use by a child, and it's perhaps less likely to cause the results that the legislature is concerned about.
I've let my colleagues talk because they didn't say much when the other counsel was up, so I thought they ought to have a chance to get on the record here. I want to come back to my questions. Seems to me this is a preliminary injunction. I've got to think about 4 questions, very, very, very difficult. And if this is commercial speech, and that's your argument, they argue higher scrutiny because that'd be better for them. But if we go with your argument about commercial speech, we're not in the higher scrutiny. It seems to me then is it lawful? I can't find that this is not lawful. It certainly it bans lawful speech. It bans speech that could be made for lawful purposes. So is it lawful is met. Is it misleading? Frankly, truthful, it seems to me it bans truthful speech. So at that point, we're at the 3 different tests that I have to do in order to meet the commercial speech test. So the first one is, does it directly advance California's interests? Is that a legal question?
I don't know of a case on point with that question.
Well, I'll
However,
tell you, there is one. It is. So far,
Well, I'll tell you, there's a case, and you should have known it. I was asking you, like, this guy kind of seems like a law school professor, where he's like, hey, is there a case? He's just asking not because he's wondering here. He's asking because it's like, hey, do you know the case? Have you done your homework? Oh, no, you haven't. So, yeah, that's not a good place for that.
Sorry, Club. And it is Alliance for Wild Rockies versus Cottrell. They both say they're legal questions. And the reason I said that is because that fashions our review. If it were
He's
like
big
a
on
jury makes a determination when they're given the law, then it would be abuse of discretion, hard standard to meet. But where it's a legal conclusion, we can look at this law and see if it really goes where it's supposed to go. And that's why I thought it was interesting how you answered
Big on
my
standard
colleagues'
review.
questions, because they're really looking at it, does it really advance California's interest? And that's the worry we have in this situation, if we're to make that determination. So what's your best argument about that?
I think you have to look at the way that courts review these cases and the decisions
I
themselves.
am. That's
Right,
what I'm
yeah,
trying
and
to
so-
bring
and
to
this
your
is-
attention.
Sure, and
he did not like that. I mean, he's laughing, but he's like, what do you think we're doing here? Like, where do you think you are right now? This is court. That is what we do here. So yeah, he did not appreciate that response.
And I'm trying, and I'd like to explain our position on how that's been done. I don't disagree per se that it's a legal question, but the way that the courts review these is not to take factual evidence, but they look at the legislature's decisions, what they base it on. So again, Edge Broadcasting, they found they did not have evidence ahead of time about whether these radio ads would affect purchasing lottery tickets. In the educational media versus Swecker case, there was not factual evidence introduced during the record in the district court about whether advertisements for alcohol in college publications would affect the underage drinking of the students. That's not how the courts review these cases.
The problem that I have with this is that it is absolutely a right that's granted by the Constitution to have advertising, right to have commercial speech. And we're supposed to deal with that as if you're taking that speech away, and I'm supposed to find pretty clearly, it seems, that it advances California's interest, that there isn't some other thing on the books that would say it doesn't advance California's interests at all. And that's my worry about this particular instance. If we go to the next, not more extensive than necessary, how can you say this is not more extensive than necessary?
Well, I think that is the technical.
This guy is mean when he's smiling. When he's smiling, that's a worrying, place to be. So, yeah.
Term of the prong, but I think the courts have made clear in the Fox case, and this court, I think, made clear in Whiting.
You cite to get to those, the alcohol, tobacco, all that kind of stuff, but we're not citing something that is dead on a constitutional right to use a gun.
Yes, Your Honor, but I think it is commercial speech.
Can I add to that? And because this really gets to sort of, even putting aside that a constitutional right, to have a gun, I think you keep citing the, smoking or alcohol or, these, but I mean, I think it's intuitive. There's a certain, maybe the reason that you don't have courts looking, it's intuitive that in those contexts that, if you put up an advertisement in the school saying, buy your Camels across the street, buy your Camel cigarettes across the street, that you're going to increase demand. I don't, at least for me, it's not at all intuitive. I mean, junior sports, I've never heard of the magazine before. It's not intuitive to me that advertising is even driving hardly any of the youthful demand, which is unfortunate for Junior Sports Magazine, I assume. But what is driving youthful demand? We don't have time, so I'll tell you. I mean, what's driving youthful demand is movies and video games and Call of Duty and stuff. That's what. So what do I do with the fact that it just seems like this law is like this weird law that doesn't. Whereas if you're trying to ban cigarettes in school, cigarette advertisements in school or cigarette advertising, whatever, that seems to have a lot more direct relationship. This law is really missing a direct relationship, it seems like.
Ouch. Yeah, he's saying hey, they're not learning this from, these magazines. When was the last time, parents in the chat, when was the last time you saw a kid reading a magazine? I don't think that is that's super common. So yeah, I think this is a solid. I want to see how she responds to this. So let's go.
Your Honor, I would say that you could say the same thing as far as seeing the products used in movies and video games and other places about smoking. prior to a lot of the laws that have come out. Certainly these days, with regard to alcohol, you see that a lot of places. I think no one to dispute there are a lot of products that advertising plays a role and other influences play a role. And I believe it's Edge Broadcasting that talks about it doesn't have to be the one solution that takes care of everything, but if it contributes to help advancing the government interest.
You can do things piecemeal, because after all, they can only do. But this, I thought that would be your answer. But the problem with that answer is that, what do we do if, like, if I think that 99% of demand for some product is driven by something entirely different, and there's really hardly any demand being driven by the thing that's actually being banned here.
And the thing is she doesn't want to go after, she doesn't want to start roping in Hollywood because they're California. She doesn't want to rope in video games because, like, LA. I think that this is a hard place for her to be.
And then you couple that with the fact that the legislature, there's stuff in that the legislature both said in the law itself, but also in legislative history, that seems like it's really trying to, it's trying to even, it actually is targeting lawful activity. Like, it actually wants to target lawful activity, not just unlawful activity.
I disagree with the statement that it's trying to target lawful activity.
But you agree that the legislature said that. Like, it said that it wanted to, the language about possess. It didn't say unlawful possession, but it just wanted to go after possession possession of a firearm by minors.
I'm sorry, I'm not aware of where in the legislative record that statement's made.
All right, it's in excerpts of record 1018. It says, when they enacted it with intent to further restrict the marketing and advertising of firearms to minors and to advance the compelling interest in ensuring that minors do not possess these dangerous weapons.
I'm sorry, Your Honor, without seeing the context of that, I don't just.
She's into, I'm not prepared. Like, she's being asked a question about this. Yeah, and this is a good point. She doesn't want to go into video games because California already lost on that before Supreme Court. She's like, I don't think that's in the record. And he's like, I'll tell you where that's in the record. And she's like, I don't know. Like, you got to know your record. You got to know everything inside and out. So, yep.
Dispute that's in the record, and I trust you that's in the legislative record, but I don't dispute it's in whatever report or statement that you state it's in, but I don't know I can't concede that it was stated in a context that I'm unaware of.
Okay, that's fine.
Okay. All right, great, thank you.
Okay, thank you.
If you guys have watched, what do you call it? My Cousin Vinny, that's the I'm done with her. Like, the thank you. Like, okay, you don't know you're not ready to answer the questions on the record. Bye, Felicia. So, yeah. And remember, she saved 3 minutes for rebuttal, so she gets to make a counterpoint. I'm not sure how much counterpoint she needs here. This is always risky because sometimes all you want to do is stand up, say, I have 3 minutes. Do you have any more questions for me? If I'm her, I don't want to gamble. Like, this is not the time to spin the wheel. You're just like, yeah, and I think this is a fair question. She's not prepared because she was hoping anti-gun judges would throw her softball questions, as is common with much of the Ninth Circuit. I think that was a problem. There was some preparation issues there. Getting up and trying to make a new point here feels like, you've gone to the casino, you've sat down, you've put $500 on like one particular number on the roulette wheel. And they spin it and it lands and you get whatever. It's like 32-1 or something. So you're sitting there with a big stack of money and you're like, you know what? Let it ride. This is not the time to let it ride. this is the time to like take your money and like go have a nice, head to the cash out window. So
I'd just like to make 3 very brief points in response to some of the
No!
questioning that I just heard, and some of the questions that came up earlier. Thank you, Your Honor, for pointing out Safari Club and Cottrell. I think appellants would also point to Laura Lard as helpful to this court in applying a legal standard to the Central Hudson tailoring analysis. Also,
what is it? Old guy on the left was nodding there and was like, okay, yep, that is correct. Good work. But yeah, I think this is not the time to play Russian roulette. Yeah, that's kind of what she's doing there. So yeah, take the win.
with regard to, I'm not trying to bring this back into strict scrutiny, but I would like to make a quick point about the fact that the things that I kept hearing my colleagues speak about with regard to, it's a totality of the circumstances test. You have to look at every single advertisement to determine whether or not it violates the law. That shows you very clearly that this is.
Oh, do not get cute. Like, I like the point she's making. It's a good point. Don't make it in that sing-songy, mocking voice, because you might piss the justices off. Do not get cute. And there's a fundamental rule of court proceeding, and that is never interrupt your opponent when they're making a mistake. And that's what she's doing here. The other side got savaged in that last half. They just got savaged with a lot of this. And now she wants to do a victory lap. She wants to spike the football and probably other sports metaphors. And I'm out of sports metaphors here, but this is not the time or the place. Your victory lap should be after you have a judgment in hand. Like, that is when you could do the victory lap. You don't get to make fun of opposing counsel. And it's a great way to get those 3 justices to decide that you are an ass. Now, I will say, look at the dude on the left. Dude on the left loves this. Dude on the left is absolutely thrilled with this. This is where he wants to be, but that's not where I'd want to be.
Content-based, and when it's content-based, and worse yet, viewpoint discriminatory like this law is, we should be using a straightforward First Amendment strict scrutiny analysis, and under that, we definitely win. But again, my third point is obviously that when we go to Central Hudson, we're not just talking about some reasonable fit, willy-nilly. This has to be narrowly tailored. And a district court decision in Tracy Rifle was really clear in a First Amendment case sort of like this one. When the state has access to tools to directly attack the harm they're speaking of, here gun violence for instance, they have to resort to those and not go to speech indirectly to dampen demand. What we can't do, what the state cannot do, is ban this non-misleading speech about the availability of legal products, and this is speech, again, directed both to minors and adults. In closing, it is not a crime to encourage young people to engage in the shooting sports. And the government cannot, in line with the First Amendment, punish the firearms industry, and only the firearms industry, for encouraging young people to shoot with legal firearms that come in sizes appropriate to their size. This is a violation of the First Amendment, and this court should not be shy to overturn the district court's decision. Thank you.
Thank you to both for the very helpful argument. The case has been submitted. Our final case we'll hear.
All right, so I just want to say what I would have done for my rebuttal time on that. I would have stood up and would have said, based on the questions you've had from my colleagues, I feel that the court has a good grasp of the issues. Unless there's any questions, I encourage you to find for us, basically. So just stand up, say, you've got an opportunity to ask me any last questions you have, and then That's it. So she could have done much worse, but I don't think the laughter there was, like, the mocking was helpful. So I think we've got one more here in the queue. I don't know. Do people want me to go over that one, or are people done for the night? I don't know where people are. So let me know on that. If you're like, hey, we're finished, or if you're saying, hey, we want to hear another. What do people think on that? I'll just watch in the chat here. I see yes. Can we do more like this in the future? Yeah, absolutely we can. Nothing wrong with that. I also am going to have something as a sort of finish out later, but so let me just see if I can find that. But all right, so let us rock and roll with the next one. We are going to roll a swoop, though, because we need to see that Zora. We definitely need to see the Zora. There's the swoop. All right, so and I'll just let's go through some super chats here and a couple of ones that I started. Will you testify in the Senate for Bill C-21? I haven't been asked to at this point, but I would be happy to do so if anybody can get me in there. If we had ham, we could have ham and eggs. If we had eggs, yeah, the if to escape the hypothetical is a dangerous place. There was a massive document release in the Delphi case today. Is there any chance you'd be willing to help make sense of it another day? Absolutely. I just need to get a copy of that. Sort of what the YouTube rules have done to creators. Yep, you got to shy away from certain topics. Say things like SA instead of the actual offense. Katana, welcome to the membership there. That is a cool profile picture. All right. What is it? Ian going for the top voices of the 2A Gundy 2024. I mean, I wouldn't mind. It would be an honor to be nominated, because if I get nominated, then hopefully I can go play around with tanks and so forth. So somebody says, funny swoop you created for uncivil law. Don't know in what world where bees and fish are in the same category. Uncivil's got a video about that, about the bee fish. Do we get to hear any decisions on the appeals that we've seen? Those will come out later. Those are not currently out there. Will I look at the Melly case? I haven't so far, but I'm not opposed to it. So, all right, let's proceed.
Today is Safari Club International versus Bonta.
Oh, so it's another versus Bonta. Then I guess we are covering it for sure. Somebody says, can I show the IR scope? Yes. So I'll just pull that up here. This isn't the scope. The scope part is attached to a rifle. But this is the IR part of it. All right, back to. Nope, that's not right. That's not. Actually, this works just fine. I get to hang out in this dead space. That works just fine for me. All right, let's keep going. I'm banned in the state of California. Yeah, people are asking, is it California?
Good morning.
Of course it's California.
Michael Reynolds of Snell and Wilmer on behalf of Appellant Safari Club International, United States Sportsmen's Foundation, and Congressional Sportsmen's Foundation. Since the court has already, and the previous parties arguing have already addressed the questions of the standard of review, and also, I think, addressed the Central Hudson test, I'll try not to go over those matters unless the court has specific questions of us regarding those. I would like to take a shot from beyond the three-point line here and discuss why I believe that the statute in
with the sports
question
ball
does
metaphor.
more than just regulate commercial speech. Commercial speech is defined in Hunt versus City of Los Angeles as speech that does no more than propose a commercial transaction. This circuit has cautioned that commercial speech doctrine is not to be defined too broadly, lest speech deserving of greater constitutional protection be inadvertently suppressed. In this case, the statute in question, not only does it engage in viewpoint discrimination for the reasons that have already been mentioned by our predecessors.
We don't have a lot of time, so maybe just let us know why you're not kind of boxed in by Sorrel and then our circuit's interpretation and retail digital network.
Well,
So I like the way he starts out here. He's watched the previous, he's watched the previous case. He knows where the weaknesses are, and he's like, I've got an argument that they missed, and so he's coming in this, and he's taking a shot at them. I think that's a solid approach there. So I'll just embiggen a little bit. I think that was a good call. Again, you see that he doesn't get through too far, and before they're saying, we got questions like, how do you deal with this issue? So let's on we go.
Because the statute in question here defines marketing and advertising more broadly than just proposing a commercial transaction. For instance, an advertisement that encourages the lawful possession and use of a firearm is forbidden by this statute, so long as it is reasonably likely to appeal to a minor. That's more than just propose.
Since this first part of Central Hudson is whether that's true and lawful, I mean, it's kind of on Central Hudson, sort of the assumption in Central Hudson is that there's going to be some things that are lawful, that things that are lawful that will be banned, right? So, or speech about things that are lawful will be banned, or speech that's lawful. So why does that not? I mean, the mere fact that this is overbroad, how does that get you out of Sorrel and retail?
Because when you cross the line into viewpoint discrimination, and you are merely encouraging, and at this point, we're not even talking about a transaction at all. We're just encouraging the possession or use of something that is protected by the Second Amendment. That is protected conduct. And at that point, they've crossed the line. It's no longer commercial necessarily at all. For instance, a junior-sized T-shirt that had an outline of a Henry rifle, a .22 caliber Henry rifle that said, know your Second Amendment rights, or your Second Amendment exists to protect you. An advertisement for that would be banned under this statute, whereas the same shirt with the same logo or the same outline of a firearm on it, a Henry rifle that said something like, these are dangerous and they're for killing people and that's the only use they have, that would not be banned under the statute. And then you've kind of got this middle category where if it said, this is useful for hunting, well, maybe it is, maybe it isn't.
But you really got to listen to what my colleague, his question was very good, because he said, given Sorrel and retail digital network, how can you go with what argument you're making? Because, as you know, regional digital network suggested that Sorrel did not require strict scrutiny for content-based restrictions on commercial speech. That's our case. And now you're trying to suggest that somehow under Sorrel, I could make viewpoint different than that content-based. Well, and that's why his question was good. He said to distinguish it. Isn't it just as well, given what we have to do under commercial speech, isn't that the better way to deal with this situation?
Well,
otherwise you've got to say, well, regional detail didn't talk about a review of viewpoint-based, only on content-based, and so therefore I can still get strict scrutiny. That's what you got to say in order to get there, because retail is pretty specific.
Well, I certainly wouldn't want to dissuade the court from striking this statute down under Central Hudson review.
Well, you're not, but you got to answer this question. It's pretty, I mean, otherwise we can get to strict scrutiny under your idea that as it relates to viewpoint-based restriction, but I've got retail digital sitting right in front of me that's saying content-based restriction is not enough to get to strict scrutiny as long as it's about commercial speech.
But viewpoint-based discrimination is a special subset of
Right,
content-based
counterintuitively,
discrimination.
as I think about your argument,
He doesn't even let him
your argument
argue
seems
it.
like your viewpoint argument would be that it's made it worse that they actually, they amended it, right? And tried to say, well, if you're advocating or if you're talking about associations or if you're talking about these certain topics, viewpoints, you could say. And so in a sense, the fact that they actually tried to make it exempt those, but would still include the one type of shirt, like would almost makes it worse under the argument you're saying.
In a sense, it does, Your Honor. And the reason for that is it exposes the viewpoint discriminatory motives of the legislature, as if the legislative history didn't already do that.
Wouldn't that be kind of true in all instances? 'Cause like, say, smoking, you got some smoking ban or something, but then you say, well, it's okay to have a shirt that says that it is attractive to minors, that says smoking's bad and has the same picture. I mean, you could use the same argument, and you don't think that's okay to ban smoking advertisement to minors, but allow a shirt that has the same picture that says, don't smoke these?
Well, yeah, I think the tobacco advertising cases are different fundamentally because, for several reasons. I think, first of all, there isn't a fundamental constitutional right to smoke or to use tobacco products or to sell tobacco products, whereas that is certainly not the case with firearms and ammunition. I think also there aren't any health benefits. I mean, every use of a tobacco or alcohol product has a deleterious effect, whereas there are many uses of firearms and firearm-related products that aren't accompanied by deleterious effects.
I think you're pointing out, how murky and what a mess our commercial speech doctrine is, but we have Retail Digital Network as an en banc case, and they said commercial speech, viewpoint content, discrimination claims, no go. So, I mean, don't we just have to follow that?
Well, there's another angle here, though, Your Honor, and I think maybe Dex Media points the direction here, because the restriction on the placement of advertisements in publications that are themselves protected First Amendment publications, it's similar in a sense to the Yellow Pages cases. Speech that may be characterized as commercial in the abstract, it does not retain the commercial character when it's inextricably intertwined. Advertisements promoting firearm ownership and usage are advocating for the exercise of Second Amendment rights, and those advertising revenues make it possible for the publications to advocate Second Amendment rights to a broader audience. Those advertisements are inextricably intertwined in even a greater sense than the Yellow Pages advertisements were intertwined with the Yellow Pages book that included the white pages along with them.
I think he's doing fairly well here. I mean, they're hitting him with tough questions, but I'm really, I haven't interrupted him for a while because I've been just interested in listening to him. So I think he's doing pretty well here.
Do you want to reserve some time?
Yes, I would reserve a few moments. Thank you.
Thank you.
So middle justice is like, hey, we'll let you off the hook here.
So I would like to start by talking about the Retail Digital Network case. I think your honors are correct. That is.
I'd like to start by addressing the thing that the justices were just saying is a problem for him. Who is surprised that that's what she's doing?
It's important in this case because it does affirm that under Supreme Court precedent, content-based discrimination certainly, and viewpoint discrimination is still evaluated under Central Hudson. So that is
Not sure
applicable
that
here.
it went as far as viewpoint. It seemed to me that it concentrated on content-based restriction. not
did,
viewpoint.
it did concentrate on
And
that.
so therefore, it would seem to me that I have wiggle room.
Why the content-based discrimination still goes under Central Hudson, also applies to viewpoint
that's
discrimination
fair.
in the sense that
I'm gonna
with
go for
respect to both
Nick
types of
after this too,
discrimination,
so.
the court in Sorrell evaluated the statute, found there to be that type of discrimination, and then discussed whether or not Central Hudson would apply based on not what type of discrimination there was, but whether it was fully commercial speech, and then proceeded to go through Central Hudson, which if it wouldn't have applied, they wouldn't have bothered to do. So the logic, I think, is still there.
Well, one of the amici really addressed this issue pretty well, I felt, and they felt like we could get there, but I wanted to make sure he felt where he was. Go ahead.
And so the next issue I wanted to address is the idea that the statute would cover a T-shirt that said something about firearm use. And that is simply not the case. Under the plain words of the statute, in Section A1, it restricts only advertising or marketing for a firearm-related product, which is defined in the statute. So it does not cover things like T-shirts.
Yeah, but there's no reason why a T-shirt
Further
couldn't
in,
advertise a firearm
In the
product.
definition of marketing or advertising, any kind of encouragement is still about a product and in exchange for monetary compensation. So it's not at all inclusive of mere statements about firearms. It is about firearm products only.
Now, going back to Central Hudson analysis, is there anything in the record that shows that restricting truthful, lawful advertisement about guns that may be reasonably attractive to minors would reduce
I'm just gonna be watching.
unlawful possession of guns by minors or gun violence?
Well, the standard for that is not that there has to be a surplus of empirical evidence. The standard can be historical background and common sense. And I think that if you look at the case law, that is what a lot of the courts have relied on in order to find that problem was met. So despite the fact.
But in 44 Liquor Mart, the Supreme Court basically said, well, just kind of hunches, general sense of common sense isn't enough. In that case, it was restricting the price of alcohol, advertisement about the price of alcohol, and says, well, theoretically, yes, if you limit the advertisement of sale prices of alcohol, it may theoretically reduce the consumption of alcohol. But they said, well, that's not enough. You need something that will show that will, quote unquote, significantly dampen alcohol demand. And here, I mean, I don't see really any evidence that, restricting ads in Junior Sportsman magazine or, what it may be will reduce unlawful possession of guns or gun violence.
Your Honor, to quote what I was trying to paraphrase before, the Supreme Court in Florida Bar did say that the restrictions can be based solely on history, consensus, and simple common sense, which is what I think the courts did in Edge Broadcasting and in Swecker.
But
I think she's going to have trouble. She was hoping that this was a panel that would think common sense is, is ban guns. But I think that she's in the wrong room for that. I think she didn't realize the room she was going to be in. But we'll see. I mean, we'll see what the verdict is.
This kind of goes back to what I was asking. I guess it's in the other case now, but the common sense aspect. I'm really struggling with the idea that there's like literally a single person out there that's reading an advertisement in junior shooting sports and then go buying a gun illegally, or reading an advertisement. There is misuse of guns by minors. There's illegal, but if we were going to look at common sense, what is the common sense link here that this type of advertising has been banned?
Again, I think there's common sense across, because the studies have shown this across all different types of products. And it doesn't mean, first of all, I think it would be very difficult to isolate a specific circumstance to show evidence that a particular ad or that a youth even process the fact that, it was advertising that caused me to do this. But I think if it contributes to illegal use and possession, I think that's sufficient, because I think that directly advances it, even if it's not a one-to-one, this one ad caused this to happen.
But to be fair, that's a little mischaracterization of my position. I mean, hopefully you can tell. My position is not that it
I
needs to
don't
be
know
one-to-one or anything. I'm
the
like
left or the center one.
It just does not pass a straight face test, so to speak, that like there's much of, if any, of a relationship.
Could California pass a
It doesn't pass the straight face test is not a line you want to hear. That is that's the court saying, but that's bullshit, isn't it? Actually, I don't even think there's the isn't it. It's just that's bullshit. So, yeah.
law says you can't have any advertisement that shows guns or violence that may be reasonably attractive to minors in advertisements.
I'm sorry, would you mind restating that?
So,
Your
yeah,
Honor?
so
I didn't
could-
Now I see a question. Do we know who the judges are and who appointed them? My understanding is that the two of them are Trump appointees, and one of them is a Bush appointee, apparently. That's what somebody in the chat was saying. And usually the chat's right about those things. I have my guess as to which one is the Bush appointee. Show of hands. Who thinks? Yeah, we know which one that would be. All right. So let's hear the question again.
California passed a law that says you can't have any advertisements that shows guns or violence or glorifies violence, and which may be reasonably attractive to minors.
So any ads for any type
Say
of product?
let's say movies and video games. So it says, look, when you see these advertisements showing Quentin Tarantino movie, you have a, hands.
Did you see her do a like a recoil when he asked that? Like, she looked like he just slapped her in the face because she did not want that question. This is not a good question for her because A, she doesn't want to get into banning all that for two reasons. One, a lot of the money in it, and two, previously lost cases. So she is right. Yeah, he's moved her right to the center of the minefield right now.
Some actor shooting people looks cool. We think that advocates gun violence. Could California ban such ads?
I think the first step in that analysis would be whether or not it's purely commercial speech. And even if you're talking about ads for a movie, I'm not
They're
sure
trying
if
to
that
sell
would
the
be
movie
purely-
here. They're not preventing making of the movie, but
Right.
they're saying when you're putting on TV where kids will watch, and it's directed at kids, could California ban such ads?
So I'd have to, again, go through the steps of the process. Again, I'm not sure that would be purely commercial speech, even if it's an ad for the movie. But if saying it was, then you'd have to decide if there's a substantial government interest. I think.
So the ad for the movie isn't purely commercial speech? Okay, that's weird.
There would be. You'd have to go to whether it directly advance and then whether or not there is a reasonable fit. I think what's important, part of the importance here is, again, even though this is a legal determination, the case law does say that legislatures are allowed to make some judgments, and there is some level of deference to legislatures' judgments on some of these issues. And so I think that has to be kept in mind here as well. Again, we're not talking about a situation where there has to be plentiful evidence entered into the record before this determination is made.
You did say you're not sure if it'd be purely commercial speech. I think what's driving you there is that it's an advertisement for a First Amendment activity.
Right.
So why would that not, I can't remember if it's just the appellant.
Oh, you just made a mistake. So he's offering, like she says, it's not purely commercial speech because it's an advertisement for a First Amendment constitutionally protected activity. And she's like, oh, yes, that's exactly it. She's grabbing onto that because she thinks he's throwing her a life preserver. That life preserver is full of lead. That's, and maybe is also explosive.
In this case or the last case, but they basically said this is an advertisement for Second Amendment activity. So why would not you? I think it sounds like you're almost getting like a hybrid, or why would that not be equally true in this case?
Your Honor, I don't.
So when he dropped the Second Amendment activity, she, you could see her adjust her positioning. You could see the smile on her face go right away. She just realized that she just got suckered into that. That was an absolute sucker trap, and she just bit into it real hard.
I don't think it is. I don't think advertisements for firearms are not advertisements for. They're not.
Ooh, she can't answer.
Explain, but they're not statements about the Second Amendment. People who want to sell firearms or purchase firearms have various views about the Second Amendment.
No, but if you have if minors have a Second Amendment right to have a firearm lawfully, right? If the Second Amendment protects minors' ability to use a firearm lawfully, then you're banning advertisement for them to do that is banning is something that relates to a fundamental right, the same way that earlier you were saying if you were to ban the Quentin Tarantino
He's having a
movie,
bad day.
might be, your instincts, I think, were that might be problematic if you're banning an advertisement for the movie because the movie itself is a First Amendment protected activity.
Well, so I think the Bolger case is instructive here, and in that case, the court applied Central Hudson scrutiny, despite the fact that it had the advertisement questions had to do with contraceptives, which the court recognized were a constitutionally protected activity. I'd also just, while I have a moment to say it, I would like to state that our position is not necessarily that minors have the constitutional right to use firearms in the circumstances in which the California law legally allows them to. We don't concede that point necessarily. It's just as part of the analysis. I'm not taking a position on that today. Just want to make sure that's clear in the record.
That's not a great place to be. So
I think that concludes my comments then. Thank you.
Great, thank you.
Counsel?
I'll have to talk fast. I've got 86 seconds.
and you're wasting them on I have to talk fast. But you see his big smile when he comes up. I hope he doesn't spike the football quite as much as she does. But yeah.
I'd like to start by saying Sorrell and Retail Digital addressed solely commercial speech. Those cases didn't deal with mixed content viewpoint and mixed content speech. Here, we're dealing with mixed content speech. We're talking about, and that's why I think Dex Media is the vehicle to get to non-Central Hudson review. Again, the statute fails under Central Hudson, but it's viewpoint discrimination, and that is presumptively unconstitutional regardless of whether it's commercial speech. The new exception did exacerbate the viewpoint discrimination because it singled out state-approved views for exemption from application of the statute. That's what the First Amendment doesn't allow. And something that is important to recognize about the content of advertising that is at issue here. Firearms are inherently symbolic of the Second Amendment and Second Amendment freedoms. The law here singles out only speakers and messages that promote Second Amendment protected products. The Second Amendment, unlike other constitutional freedoms, actually guarantees the right of access to certain products, that being firearms and ammunition. Now, of course, this statute goes far, far further by restricting firearm accessories that are defined so broadly they can include things like optical gear and ear protection and things like that. But the important point is that a reasonable onlooker who sees the promotion of a firearm would understand the inherent pro-Second Amendment message that the firearm or the advertisement for that symbolizes. And that's the fundamental freedom that's at stake here. That's the content and the viewpoint that is being discriminated against and how we get to strict scrutiny.
Great, thank you.
Thank you, Your Honors.
Thank you both for the helpful argument. The case has been submitted and you're adjourned for the day.
Thank you.
All right, so that was it. They're done.
This court for this session stands adjourned.
And that gavel, hit means everybody can go home. So, all right, let's pull this down here, and will put me back up. So that's appellate court. As you can tell, appellate court is a very different world than trial court. Trial court is a what is it? I see lol Ian. Why were invited by you? I don't know what that means. Trial court, you're trying to shape the evidence, right? Trial court, you're trying to, you've got to get the right evidence out of witnesses. Appellate court, you can try to spin it a bit, but you can't you can't fix any problems with your case at that point. Like, if your case has a problem, then your case has a problem, and there's nothing you can do about it, other than to learn how to deal with it, like how you can roll with it. So appeals are much purer law, if that makes sense. An appeal is you've got to be pure on your arguments, you've got to be strong on your arguments, and like your ability to cross-examine doesn't weigh in, that kind of thing. So I think it's sort of a more pure application of the law. And I like appeal work. Appeal work is a lot of fun, but you can see that appeal work is challenging because stuff can go sideways on you in a big way. Stuff can go sideways where you're just like, you think you're going to get to read out this argument. The justices or the judges in this case just don't want to hear it. And you have to really know everything in your case because, as you can see, that moment where he's like, well, what about this in the record? And she's like, I don't know that part of the record. And he's like, oh, okay, then. That's an opportunity that's just like, you have that opportunity to bolster your case, to make it better, right? To address that concern. And if your answer is just, I don't know what you're talking about, then you lose, right? Then you're getting closer to losing. Because the judge certainly wanted to hear about that. The judge certainly thought that was relevant and germane and so forth. And she's just like, now she's saying, I don't know the context. This is a situation where you might want to have that. And this is actually a place where I really like having a laptop. I think a laptop is a fantastic tool for this, because if you end up with them saying, well, I have this, you're like, can you quote this? And you hit Control F and you type the quote in as they say it, and you find it in your record, and then you can look for it. Because, maybe you don't have everything memorized. Maybe you don't know what all is going on, but it would be good to check that. So that's kind of that. Now, unless we'll hit, I think we've got one more super chat here that we'll hit. Rhineman YYC, keep the appeals content coming, maybe in smaller bites with more commentary. That makes sense. I think some people got a little tired, after we did 3 of them here. This is where hopefully bad law goes to die. I agree. I'm going to wrap this up because I think Rackets is about to go on, and I might check that and watch that as well. I think that there is a really good argument here as to, this is like thesis defense. Absolutely. Also, you really have to have a good assessment of your own arguments. And what I mean by that is that you have to really know where the weak points are. And it can be hard to do. Sometimes you're going in, you're like, I think this is a really strong argument. And they're like, you are too deep into your own argument to see that. Now, before I go, I want to share with you guys a video. And this video is completely not law related, although it is kind of, I guess, tangentially. So, it's very tangentially law related, I guess. But so the story on this one is just that I went to, and this was some time ago, it was Caesar Day. I went to a, what do you call it? I went to a little tiny pub, like a little tiny bar here. And what is it? The little tiny bar that I was at. I said that I wouldn't review my Supreme Court for fear. I would, if I review my Supreme Court appearance, I will just be talking about me, basically, like my experience, my feelings, etc., as opposed to anything else. Now I'm trying to set up. I've been having a lot of trouble with setting up redirects. So I don't think I can redirect to Ricada right here. So thank you very much, Joe Loy. But yes, Ricada's on. It doesn't look like I've got redirect privileges at this point. So I'll have to get that set up. I'll have to talk to him. I just forgot to ask him. But I want to show you guys a video that is, this is somebody who I ran into there. She's given me permission to share this with you guys. I think it's really impressive. She was just playing like this little open mic night. And so I kind of want to share that with you guys because I think she should get more eyeballs. She deserves to be a little more, a little more attention than she's got. So, all right, I'm going to roll that. And hopefully you guys will enjoy it as much as I did there. And yeah, hopefully, I don't know. She might have YouTube set up to hit me with a strike. So we'll have to see if that happens. If so, hopefully she'll take it down. But here we go. Let's roll this video.
And I still can't settle my eyes. My way of making it feel alright. Casually make it burn for me. Okay, well I guess I made up my mind. Kept it straight for days, slipping sideways. I'm a little inside out, out, out. I've been running around lately, doing what I want. Just don't tip them off, 'cause I'm not sorry. You keep saying I'm crazy, but I get what I want. Sneaking around, can't hold me down, 'cause baby I'm a bad, bad criminal. No point in trying to tell me to stop. Is it really a crime if I never get caught? Casually bending honesty, keep making them think whatever I want. Kept it straight for days, slipping sideways. I'm a little inside out, out, out. I've been running around lately, doing what I want. Just don't tip them off, 'cause I'm not sorry. You keep saying I'm crazy, but I get what I want. Sneaking around, can't hold me down, 'cause baby I'm a bad, bad criminal. Baby I'm a bad, I'm a bad, I'm a bad, I'm a bad, bad criminal. I'm a bad, I'm a bad, I'm a bad, I'm a bad, bad. The devil works through idle hands to fuck up my plans. You know I'm not just cynical, cynical. I'm a bad, bad criminal. I've been running around lately, doing what I want. Just don't tip them off, 'cause I'm not sorry. You keep saying I'm crazy, but I get what I want. Sneaking around, can't hold me down, 'cause baby I'm a bad, bad criminal.
So that is Alicia Love, who, as I said, I just went and she was playing an open mic night, and I went, holy crap, she is way better than it's open mic night at this kind of not quite a dive bar, but not like super high end. And I was just like, she's way better than this like little open mic deserves. She just really, she really sort of leapt out. So she is on Instagram. She's on YouTube. I've got the link to her YouTube video there. If you follow that, you can find all of her other links. She's on Spotify, all of that stuff. So check that out. I just kind of wanted to promote that because she's a local artist, and that I was impressed as heck with her singing. So check it out. And I see she'll go places if she plays her cards right. She's got excellent singing, excellent songwriting. I think she's got all the potential to take off. So I want to see it happen, because I was just like, holy crap. So anyway, I'm gonna roll the outro here, and I will see you guys next time.